don't know.
Oh, it's funny.
It was like forever to come up with that. Yes.
Okay, I would like to call the meeting of the East Windsor ZBA for Monday, October 7th, 2024 to order officially at 7:01 PM. Our first item of business will be establishing a quorum. We have 4 regular members, and I will appoint Scott Morgan as an alternate to the actual hearing today, giving us 5. Next up is the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, a nation under God, indivisible, with liberty and justice for all.
Okay. Next up, we have 2 hearings today, one of which seems to be pretty straightforward. So I'm gonna ask for a motion to move ZBA 2024-05 to the top of our order. If somebody would like to make that motion.
Make a motion to move out of orders, zoning board of appeals 2024. 5 applicant owner Matt J. Riley. Park Plaza MH LLC is requesting a 10-foot variance for the replacement of a new mobile home from the required 15-foot setback from the adjacent mobile home per section 808.c or 1C, excuse me, of the town of East Windsor zoning regulations. 294 South Main Street, lot number 11, MLB 00205-098, zone B1.
Okay, any discussion on that? No? All those in favor, say aye. Aye. That is unanimous, so we will move forward with hearing ZBA 2024-05 first. Can the secretary read the legal notice? And that might need to be.
That might be.
Yes, yep.
This is case ZBA number 2024-05, applicant owner Matt J. Riley, Park Plaza MH LLC, requesting a 10-foot variance for the replacement of a new mobile home from the required 15-foot setback from an adjacent mobile home per section 808.1C of the town of East Windsor zoning regulations. 294 South Main Street, lot number 11, East Windsor, MBL 002-05-098, zone B1. Copies of the above applications are available on the town clerk's and the zoning board of appeals webpage on the town website. All interested persons may attend the public hearing to be heard on this topic. That is a legal notice from Danielle Boudreau, Assistant Town Planner, Zoning Enforcement Officer, and it appeared in the Journal Inquirer on Friday, September 20th, 2024, and Friday, September 27th, 2024.
Okay. So we'll begin with a presentation from the property owner. Is Mr. Mark J. Riley here?
No, Matt's partner, Mark.
Okay.
Just a statement, is that what you're?
Yeah, just explain why you're.
Yeah, so we bought the park, I think in 2015, it had a lot of vacancy. We put actually 11 brand new homes in there. The park had been, I forget the gentleman who owned it, but they hadn't replaced any homes for a long time. We put 11 new homes in there. And there were still a few homes that are older. Somebody had bought the home last year, the home that was located on site number 11. And they bought it to flip it, which doesn't usually happen in a mobile home park. Usually we'll just buy it, they live there. But with their lack of housing, people think that mobile homes are a quick little flip. So she decided to try to flip it. She happens to live in a mobile home park in another town and she couldn't do it. It was beyond her ability. So without telling anybody, she actually removed the home from the park, which has never happened to me in our entire history, where somebody just picked up a home and took it out and nobody knew it. So we did notify her that she broke the lease, broke all the rules of the park, and also didn't file a removal certificate with the town. So we're helping her do that to take care of whatever. I think she already paid the liens that might have been on the home already, which is only $200. So when we went to go apply for a home, what we realized is two things. One is they don't make homes as small as the homes that were built in the park to begin with, which some of them are only 10 feet wide. I don't know, you guys can live in a 10-foot wide, anything, but it's small. And so usually those are only one bedroom. And most of the homes that we rent are 2-bedroom, 1-bath, or 2-bedroom, 2-bath. And we also do it about $500 less than the market rate. We rent them for about $1,000. That's if we own the homes. Lot rents half that. So when we went to go apply, we hadn't realized, but the person that lives in the home to the right, number 10, was given a building permit by the town about 13 years ago to double the size of his own home, which again, doesn't happen very often. By him being able to double the size of his home makes me have the inability to actually bring in a home that's built today to meet the 15 feet that's required. So that's why we're here today. So the home that we're putting in is only 12 feet wide, which is the smallest that a manufacturer will make, but it's doable, and it'll be a 1-bedroom, 1-bath, 12 by 56. It'll be brand new, so it'll increase the property taxes to the town, and it'll look a lot nicer in the community, but it'll be closer to the guy to the right, but it'll be fine to the person to the left. Does that make sense?
Is there any questions from the board?
Yeah, is this, the trailer that you're moving there is going on the empty spot that's?
Yeah, number 11. Yep.
I drove through there.
I own number 12, the one next to it, and the gentleman owns number 10. That's the gentleman that owns number 10 is given a building permit to essentially double the size of his
Yeah,
10-foot home.
I thought when I drove by the empty lot was there and then the one to the left had a number 11 on it. So that's why I was asking.
Oh, no.
Okay,
Number 10 is the home that is.
That's double
Issue,
with
the
the-
one that he doubled his. I
right.
think we would never have allowed it under our ownership, but it was prior to our owning the community. And remember, that wasn't helping him at the time. Really should never have let him do that, because then it would make anything like this not possible by bringing in a relatively new home.
Yeah. So I'm sorry.
No, good.
We're increasing the size from a 10-foot
To a
spot to a
12-foot.
12.
Yeah.
So the actual 10-foot variance is not necessary. It's just,
No, it's going 2 feet wider, but
Yeah.
again, by him taking that extra 10 feet,
you don't.
yeah, he wasn't, you were already you were already in violation by allowing him to build the tent to the extra 10 feet. He was already closer to begin with, so now we're closer, yeah. I wouldn't even want to put a 10-foot home. I mean, it just wouldn't, it's not viable for anybody to live in.
I just wanted to clarify, is this a case where you have to notify abutters, or is this different?
This is different. This is so I own all the land. So in a sense, people are renting the lot from me. It's like a condo.
Gotcha.
It's the best way to do it. We typically say it's like a parking lot because homes can be taken out, but it's basically one sheet of land and homes can come and go and they just go, like this. So I own all the land, and half the people rent the lot from me. And the other half of the homes I just happen to own because they were so small when we bought the community. There's no market to sell a home that's only 12 feet wide, 1-bedroom, but it's fine renting them because like I said, we're offering them below market anyway. Thank you.
Everybody good? I will open it up to public comment on this hearing. If there's anyone out there that would like to speak about this. Seeing none, I think I'll take a motion to close this hearing. Anybody would like to make that?
Make a motion to close the hearing.
Second.
Motion is seconded. All those in favor? Aye. All right, it's unanimous. So now we will move forward to a discussion. If anybody has any thoughts on this or would like to make a motion to approve or deny.
Well, I have a staff memo for,
Yes.
yeah. And for the benefit of the audience that doesn't have this in front of them, I'll read the staff memo. I know you all have it. So the applicant is requesting a 10-foot variance for the setback requirement for the replacement of a mobile home on an existing lot. In January of 2011, the former building official granted a certificate of occupancy for a permit for an addition to an existing trailer on the adjacent lot, Lot 10. This was granted without any prior approval or permit from the zoning department and in non-compliance with the requirements of the zoning regulations, section 808-8081C, which states no mobile home or accessory structure shall be parked or set up within 15 feet of any mobile home in said mobile home park. So the staff recommends that this variance be granted. Had this non-conforming addition on the abutting lot not been approved prior, the applicant would have been able to meet the required setbacks for this replacement trailer. And generally speaking, there are very few zoning regulations that apply within the main parcel of a trailer park at this time, and the granting of a variance for this replacement trailer would not be infringing upon the regulations or the rights of the surrounding trailer owners any more so than the original allowance of an abutting addition. We recommend the approval of this application for a variance, and we've provided you with a motion to consider.
Thank you. Would any member like to make a motion?
I'll make a motion to move to vote.
I think you have to read them.
Read it. Make a motion to move to vote to ZBA 2024-5. Read the whole thing.
I think so.
Yeah.
Applicant owner Matt Riley, Park Plaza MH LLC is requesting a 10-foot variance for the replacement of a new mobile home from the required 15-foot setback from an adjacent mobile home per section 808.1 of the Town of East Windsor zoning regulation 294 South Main Street, lot number 11, MBL 002-05098, zone B1.
Just to be clear, this is a motion to approve.
Motion to approve.
Second.
Motion and seconded. All those in favor? Aye. No opposed? This motion passes.
No, I got stuff to do. But you need to go now. Later down a little bit. I'm coming.
We good. So with that, we'll move on to the next hearing. And before we begin, I'd like to start with a brief overview of the process. We will begin with a presentation by the property owner, who may call witnesses and provide documentation in support of their position. Any documents submitted to the board will be marked sequentially as exhibits and become part of the record. Following the presentation by the property owner, we will open the floor to questions by members of the board. Then we will follow with a presentation on behalf of the zoning enforcement officer. The ZEO may also call witnesses and provide documentation in support of their position. Any documents submitted to the board will also be marked sequentially as exhibits and become part of the record. Following the presentation, we will open the floor to questions by members of the board. After presentations by both parties and questions from the board members, the public will have the opportunity to provide comments regarding the appeal. After the public comment, the property owner will have the opportunity to address any issues raised during the public comments. After the property owner responds to the public comment, the board will have one last time to ask questions before the hearing is closed. I will ask the secretary to now read the public notice or legal notice.
This is for ZBA number 2024-04, West River Farms LLC, appealing the notice of violation of special use permit June 9, 2015 approval. Due to lack of proper installation and maintenance of sedimentation and erosion control measure regarding Shank Road, 329, 331, 339, 341 Scantic Road, East Windsor, MBL 003-34-60, 62 and 62-A, Zone MFDD. Copies of the above application are available on the town clerk's and zoning board of appeals webpage of the town website. All interested persons may attend the public hearing to be heard on the topic. Danielle Boudreau, Assistant Town Planner, Zoning Enforcement Officer, and this was in the Journal Inquirer on Friday, September 20th, 2024, and Friday, September 27th, 2024.
Okay, thank you. We will now hear the presentation on behalf of the property owner.
Good evening. My name is Bridget Gallagher, and I represent the property owner, West River Farms LLC. Just Just before I start my presentation, just one point of order. Attorney Ron Howard is here. He's sitting at the board's table with the CEO, of course. My understanding is that Attorney Howard was appointed or hired by the Board of Selectmen for purposes of just this application and is not representing the board. He is representing the zoning enforcement officer. In my experience, typically the zoning enforcement officer and any counsel that they have do not typically sit at the table with the board during the hearing and the deliberations on that. Of course, it's up to the chair as to whether or not you want them to sit elsewhere.
Okay. I don't necessarily see an issue. If you feel you need to recuse yourself to the seat over there, otherwise I feel I'm fine with you being there.
Yeah, for the record, it's Ron Hood from Bartlett and Grippy, and I'm here on behalf of the zoning officer tonight. I understand that it's the practice in East Windsor for the zoning officer to sit at the table. We certainly won't participate in any deliberations, and so
Okay.
we'll stay here.
I'm happy for that.
Thank you, Mr. Chair.
Mhm.
So I have also, just for a housekeeping matter, I have also submitted various exhibits, including a picture of the sign that my client posted back in July at the site that is still up there. It's posted and it's still up there. I've also submitted several exhibits, and I do have hard copies for the board members to hand out now. There's a few additional that I also did submit that Ruth Ann has there, and some photos and other items.
Okay.
And since we do have some members of the public here who might be interested in speaking, I do have a copy available for them. Actually, can I just
Yeah,
leave that here?
you can leave it there.
So also present here with me tonight is my client, Jeff Ressler. He's the sole member, meaning the sole owner of West River Farms LLC. His engineer, Dana Steele, who some of you may know from J.R. Russo and Associates, attorney David Berry, whose colleague represented my client during the subdivision approval process. His paralegal, Michelle Villeneuve, also from that office, attorney Alex Bowen, his closing attorney, who's trying to manage the situation that has arisen due to this notice of violation. And then obviously there's a number of other individuals here who may speak, but those individuals I just named are part of the team basically that we would like to make the presentation on behalf of the property owner. So the notice of violation dated July 2nd. I know you all have a copy of that. I did put it in my exhibit book as well as Exhibit B. This relates to my client's 69 lot subdivision off Scantic Road, which was approved back in June of 2015. It was to include internal subdivision roads off Scantic Road, which would eventually become public streets once they're built to town specifications and accepted by the town in due course. It included 18.5 acres of open space that was located mostly in the town of South Windsor, and includes land along the Scantic River. It was to be accessed by a private road, which has existed for many years, known as Shank Road. Forgive me if I'm not pronouncing it correctly, but that's what everyone tells me is how you pronounce it. There's others who live there, who may correct me tonight. There are 5 houses on Shank Road. None of them are part of the West River subdivision. According to the subdivision records, the assessor's records, the oldest house there was built in 1900. I don't know if that's entirely accurate. Sometimes those assessor's records are off, but it was in the Shank family. And the newest house on Shank Road was built in 1990, according to the assessor. There's also a business at the end of the road where it goes into South Windsor. Some of you may be familiar with it, South Windsor Auto Parts. Most of Shank Road is paved, not fully once it crosses into South Windsor. So the notice of violation relates mainly to the maintenance of Shank. It does reference some erosion and sediment control issues, and indicates that it feels the lack of maintenance along Shank Road has exacerbated the condition of Shank Road. And your CEO put one specific direction in that notice of violation of steps that she wanted my client to take. And this is on page 2. I've highlighted it there on Exhibit B. It says, you are hereby issued this notice of violation for non-compliance with condition number 8 of section 2 of your approval, and ordered to effective immediately submit an appropriate and acceptable maintenance agreement for Shank Road. Now, we acknowledge my client did not ever submit a maintenance agreement for Shank Road. In fact, my client can't now submit a maintenance agreement for Shank Road because he no longer owns or controls Shank Road. He actually conveyed that property out, which was contemplated by the approval itself. And the reference to that section with the condition was really taken out of context because it was among the requirements of a condition to deed out that open space with Shank Road to a third party, which was specifically East Windsor Scout Hall Building Committee, Inc. So to explain this, unfortunately, I think we need to go back to the beginning. Got a long history, and I ask that you all bear with me because I do think it's important. So I have included all the minutes from the planning and zoning approval process, which was a lengthy process. It was a complex application. It's a decent size scale subdivision. There was a lot of detail to it. So if you look at Exhibit C, I've included the first meeting minutes there, and I've highlighted some sections talking about the open space specifically and Shank Road. So page 3 on Exhibit C indicates the open space would include a 16-wide gravel access road beginning at Shank Road. So I believe they mean the end of Shank Road at that point, the end where it goes from the pavement into South Windsor. It's a narrow road to begin with. Both the East Windsor and South Windsor Fire Department have agreed on requested the proposed road width. The access road would include 2 turnaround areas. The applicant is proposing to transfer open space to Scout Hall Building Committee. The open space would be open to the general public, subject to reasonable rules such as no alcohol, open dawn to dusk. Apparently, and you'll see this later on in the exhibits, the town of East Windsor didn't really want that open space. They didn't want to own land in another town for whatever reason. And so somebody suggested along the way they go to Scout Hall in the staff workshop meetings. And apparently Scout Hall was very interested in it. Now, there was a lot of discussion about Shank Road because many residents of Shank Road showed up at these meetings, as is their right, and they asked some questions. Fair enough. So if you look at page 6, one of the residents, Ms. Saya, suggested or asked if they were proposing drainage. She asked if it would remain paved. Mr. Steele, who's with us tonight, reported the drainage would run along the grass area north of Shank Road, which will be paved and will remain the same as it is now, but Scout Hall Building Committee will have ownership of the right of way. Mr. Steele reported that they won't be tearing up Shank Road for drainage. Mr. Sias reported that when The church owned it, which was my client's predecessor, that her land flooded, but they put in a berm and she wanted the berm to remain. So there was a lot of discussion regarding drainage. And basically, it appeared to me reading this, and I wasn't there, but it appeared to me reading this that they didn't want a lot of work done in Shank Road because they were concerned about it. If you look at page 7, town planner back then was Lori Witt. Some of you may know her. I know her. She, on page 7, emphasizes that the open space should be for passive use, right? For which is often what's done with these open space subdivisions. It's just for passive use. These subdivisions are created where you have the houses more clustered together, so there's less impervious surface. So you save some, environmentally sensitive area or some, open area that can be used for recreation purposes. Lori Witten asked the applicant if they had any discussions with Scout Hall Building Committee regarding their intended use. And then a member of Scout Hall Building Committee, Vice President Paul Anderson, spoke. He confirmed that they would like to acquire the land, and they've discussed security measures. The uses would all be passive. They might have an outdoor billiard. Lori Witten again, page 8, clarifies it has to be available to the public. The chairman who led at the time, noted that Shank Road is paved, and he asked if easements would be created to allow people to use the open space. Mr. Usury, also from Russo, replied that easements would be created to the town to maintain a drainage basin that was going to be in the open space in the back there in the area of Windsor, and that the Scout Hall Building Committee will own the road, and that there will be easements in place for the residents. That was the concern. They wanted to make sure that their right of passage was not disturbed. There was a question asked by a commission member who plows it. It was indicated that the people at South Windsor Auto Parts plowed the road at that point in time. I don't know if that's accurate or not. Mrs. Sayas, who was one of the residents identified on Shank Road, said that the residents there assist as needed as well. She again reiterated she didn't want to lose her rights of access. Attorney Jacobs, who was representing my client at the time, said that he didn't think there was a deeded right, but if Scout Hall becomes the owner and never steps foot on the property, then they would continue maintaining it just the way that they have in the past. Now, the next meeting, April 28th. Again, page 5. It's meant to be provided to allow access to the basement. Mr. Steele indicates he didn't think maintenance of the drainage basin would incur a significant cost to the town of East Windsor. So town of East Windsor is going to be maintaining the drainage basin, which by the way was completed in 2017. And one of the additional exhibits I submitted was an as-built of that. Page 6. Maintenance of Shank Road relationship between Scout Hall Building Committee and the residents. Dana Steele said he thought that Scout Building Committee was sensitive to the concerns of the Shank Road residents. He referenced a memo which they submitted that outlines potential uses and their willingness to work with the residents of the road. Their memo is Exhibit G. It describes what they might do with the property, their track record. I think a lot of people are familiar with them in town. And then in the second paragraph says, we are developing a relationship with the Shank Road residents. Our goal is that the maintenance of the road will be in its current condition or better. And the responsibility of, I think his acronym is East Windsor Scout Hall Building Committee, with the help of the residents, right? They didn't overcommit. They didn't commit to doing all the work. And that was a consistent theme in the actual hearings. Page 7, Diane Shank reports that she has a shallow well. She was very concerned about that drying up, if there's work in the area. On the next page, there's questions about that. Mr. Steele indicated they would be collecting the stormwater and sending it to the basin, but some of the surface water will infiltrate back into the ground. Ms. Saya said that all the wells on the road are shallow. Rebecca Shank below says, water pressure isn't good. She's concerned with losing her water. Again, Rose Molka says she has a shallow well and it's in the middle of the road. So, so there's a lot of concern about doing anything to disturb any improvements that are in Shank Road. On page 9, Doug Munson says what they really want, Scout Hall Building Committee, is help from the residents. They had a meeting. I'm reading some minutes. Yes, sir. And he suggested that Scout Hall wants the residents to help maintain the road. Page 10, Scout Hall says that they suggested they would maintain the road in as good a condition as it is now. Maybe put in some paving. Okay. Next page, page 11. And I know this is very tedious, but it's very important because this was not an oversight. This was not an oversight at all. There was a lot of discussion on this. Page 11, Mr. Burnham from Scout Hall says there will be more meetings in the future, meeting with the residents of Shank Road. Everyone will be a team. Chairman Ouellette asked that they have a meeting and with the residents again before planning and zoning makes a decision. They said they wanted it plowed in its current condition. Again, the town planner, Lori Witten, indicates they need a guarantee that the open space will be available to the public in perpetuity. That's what was important. She felt that should come from Scout Hall Building Committee if they are taking responsibility. The chairman asked her how that could happen logistically to make sure there's access for the public, about it being a condition of approval. Then Attorney Jacob said he felt it would be acceptable to everyone if the issue were addressed in a condition that the open space will be deeded to Scout Hall Building Committee and will be operated with the following requirements. And they went through those requirements to go through in the final approval. The page 12, Alan Saya says it's going to be difficult to improve Shank Road. The first 200 feet, there's a building in the road. There are wells 10 feet off the road. Septic systems could be close as well. Doug Munson questioned why not improve the dirt that comes out onto Shank Road. And Mr. Munson cited issues with septic system locations and the building in the road. Chairman Ouellette suggested that the commission is now hearing that there are other economics that would impact the improvement of Shank Road. So we've got all these physical improvements that everyone's talking about. It's not the easiest thing to decide what to do with Shank Road. Now remember, the purpose of Shank Road, the whole function of Shank Road, is just to give legal access to the open space. It doesn't affect my client's subdivision lots. My client's building other internal roads. It's a side issue in the big picture of the subdivision application. But they're hearing some concerns from neighbors. They don't necessarily want to interfere with those improvements that are out there. The final meeting where they approved, excuse me, this is not even the final meeting. Exhibit E, May of 2015, page 5. In order to address the concern about the shallow wells, our engineer, Mr. Steele, proposed an infiltration system to allow the water from the roots to go back into the ground to recharge the groundwater, to mitigate the groundwater being reduced by the installation of utilities, and impact, any potential impacts on the on the wells. So ironically, they're concerned about my client's drainage plans being too aggressive, that they're going to dry up their wells. Finally, Exhibit F are the final minutes from when my client's application is approved. And the very lengthy conditions are read into the record in their entirety. And the application is back to the con. So, and we'll go through those conditions in a minute. Exhibit H, colored map that Mr. Steele was kind enough to put together. I think you have a larger copy. This is the open space. This is what my client conveys to Scout Hall. The interest in this area that is the road. This is Shank Road here. All of this open space here. Okay, this is in East Windsor, and there's a little pedestrian access way, 10 feet wide, which was intended to just give the residents of the subdivision the ability to access it without having to go all the way down to Scantic Road. So now my client's obligation to convey all of that, which is set forth in Exhibit I, which is the flow. Now, I think you will note that this approval is very detailed. Okay, this is obviously written long before the meeting in contemplation of all the conditions that have been discussed. 6 pages of very specific conditions, 25 sheets of mapping, all of which have a lot of detail in them. I know this board is familiar with the type level of detail that can be in some of these maps. And then the conditions start. Conditions met prior to the signing of Mylars. And then the conditions on page 3. Conditions that must be met prior to the issuance of any permits. Now, this is where we start seeing the requirements for my client to deed out to Scout Hall. Number 5 says, executed deeds for any proposed conservation, access, or drainage easement and open space dedication must be approved by the town attorney and filed on the land records prior to any permits being issued. These should be filed with Mylars. So this was before my client could get any single permit, before he could do anything on the ground. He had to get those deeds done. He had to submit them to the town attorney for approval. Now, condition 8 under that same section prior to the issuance of permits is specifically about the open space. Deed title for open space to be transferred to East Windsor Scout Hall Building Committee, Inc., a nonprofit organization in fee simple, and must state that as a condition of approval for West Farms, that the property is to remain open space in perpetuity for all people to have access, subject to hours of operation. 2, that the ROW right-of-way known as Shank Road be maintained as an access for residents on the road and to access the open space and detention basin. That the developer will be responsible for building the detention basin, which I've indicated has occurred. That the town of Windsor has the right of ingress and egress for maintenance of the detention basin once established. That an easement for public utilities be established. That the open space remain passive in nature, including hiking, picnicking, boat access, and camping. And that any changes in use be approved by the town of East Windsor, the town of South Windsor, if legally required. Because remember, it's in South Windsor. And that should the Scout Hall cease to exist or desire to sell the property, that the town, being the town of East Windsor, shall have the right of first refusal. Should the town not want to take ownership, that the property be transferred only to another nonprofit agency that will maintain the property for these conditions. Now, I'm just going to show you page 5. There's various conditions that must be met prior to the issuance of any certificates of occupancy. And I'm pointing this out to you because that's what's being withheld right now. Certificates of occupancy. My client has completed houses sitting there, and the town obviously issued permits for these. Remember, this approval was 9 years ago. And just this year, the town decided they're not giving any COs out. Now, once they give the permit, there's a belief that the prior conditions for permits have been satisfied, right? Lori Whitten was very sharp. You know, she was a very experienced planner. She didn't miss anything. She approved what happened with the conveyance, and so did the town attorney, and we can document that, and I'm going to show you. But it is important to stop here and look at the things that are required for getting a CO. These are things that are very site specific. They're not, you know, preconditions that an applicant has to follow. Final approval and connection fees for WPCA, site improvements, final grading and seeding, additional bonding, inspection fees, you know, iron pins in place. These are very site specific, because who would go and build houses without knowing you're going to get your CO, right? I mean, you do all this preliminary work and you don't get, and then they're withholding COs. Now, Exhibit L is the actual deed that my client used to convey the open space, which included Shank Road, of course. And that is recorded. That's a recorded copy. It was granted to Scout Hall Building Committee, Inc. This was prepared by attorney Lenny Jacobs, who unfortunately is retired and because of some health issues is unable to give us his own explanation. His partner is here and can speak to the validity of some documents that I'm going to show you here. So this has various deed restrictions, including that very important one to Lori Whitten: the property shall remain open space in perpetuity for all people to have access, which is here described, subject to hours of operation and reasonable rules. Number 2, the Scout Hall Building Committee, Inc. shall allow Shank Road to be used as an access for residents living on Shank Road, in addition to allowing Shank Road to serve as an access to the open space and detention basin being conveyed herein. Now, if you look back at the approval, those words are not exactly what's in. And I'm not going to sugarcoat that, right? I mean, it's not. And why they were modified, we don't know. And unfortunately, Lenny Jacobs isn't here to tell us why. I suppose it was his interpretation, right? Shall be maintained as an access was what's in the approval. And this is different language here. Okay. However, the town attorney approved it. So if you flip back to Exhibit J, this is an email submitting deed and various other documents, a drainage agreement and a quitclaim deed that my client used to merge a couple parcels. March 3rd, 2017. Dear Attorney Whitney, attached are copies of the revised quitclaim deeds and easement along with copies of documents with your comments. Please let me know if these are acceptable. Diane Whitney, I expect to review these today and get back to you. You flip forward a few pages, you will see statutory quitclaim deed. It has that same language that I just read you that ended up in the final deed. Okay, number 2, Scout Hall Building Committee shall allow Shank Road to be used as an access for residents living on Shank Road, in addition to allowing Shank Road to serve as an access to open space and the detention basin being conveyed here. These handwritten notes, we don't know if they belong to the planner or if they belong to Attorney Whitney, but she did not make any changes to that documentation. Now, the planner was sitting in all those meetings. I don't think Attorney Whitney was. Attorney Whitney was a very experienced attorney. She's with Pullman and Conley. She's semi-retired now. I actually had a case with her around 10 years ago. That was a notice of violation on an East Windsor matter. And she and Laura Whitten were a very good team together. She approved the deed. I did put in here just so you had it all be included. a quick lead in the drainage easement that we're also in. K, Exhibit K is the copies of the revised quitclaim deed. Now, we assume that Michelle and Attorney Jacob have made those changes. Along with copies of the documents with your comments, please let me know if these are acceptable. These documents all look fine. I will tell the planner that I have approved. I am bidding. So my client, in reliance on that, signs this deed. He conveys title over. He no longer has ownership or control of Shank Road. He relies on this statement by the town attorney that the conveyance and the language in the conveyance is adequate. He gets permits. A lot of time goes by. Nothing is wrong. He builds his infrastructure. He spends a lot of money out there. He's boxing out roads. He's putting in utilities, drainage. He's doing all this work. It takes 2 years just to put the infrastructure in. Then he starts building houses. Okay. He has 20 houses built and sold there to date. No problems. No problems. Now, to complicate it even further, fast forward a few years, and it turns out Scout Hall, this property's not really working out for him. And they don't really, oh, excuse me, before I tell you that, in 2020, my client has to go and get an extension. These are 5-year extensions, 5-year approvals on subdivision. My client goes in June of 2020. I put those minutes in here as well, just to show you the whole history. This is M. He gets his 5-year extension, no problem. No one makes an issue about Shank Road. And that's M and N. And there's a subsequent whole extension contains the same exact conditions. Essentially just changes the completion date. Now, to complicate issues, Scout Hall, as I mentioned, decides the property's not really working out for them. They don't want it. Why, I don't know. He's speculating, but they start talking to the town south. And South is interested in acquiring it. So they have to go, remember, to the Board of Selectmen and get approval, transfer it. Board of Selectmen has the right of first refusal. So December of 2020, they go to the Board of Selectmen. This is tab P. And they have a discussion. First Selectmen discusses the property a little bit, says it's in South Windsor. He reviewed the condition. He didn't think there was a point of egress for commercial from South Windsor, which is accurate. Okay, there's no road from South Windsor that can be utilized to access this property. And it doesn't seem that any could be constructed because there's the sensitive wetlands areas and other private property around there. So they have to go into East Windsor to access this property. And of course, they have to utilize Shank Road. So then he gives history. He does say that Jeff Ressler, who developed West River Farms, originally approached the town of East Windsor about this and they didn't want it. And he thought that this would have the joint benefit of a park, because that's what South Windsor said they were interested in doing. And it would be, you know, for the benefit of East Windsor and South Windsor residents, but operated and maintained by the town of South Windsor, available for public use. Now, one select person, D'Souza, said she didn't want the town to own the property in South Windsor, but she questioned if the people on Shank Road would be impacted by the additional traffic. That was pretty much glossed over. And she did support the selling of it. Okay, and it was sold for $1. In each instance, it was sold for $1 when my client gave it and when Scout Hall gave it. So there's a formal there's a formal approval Q in letter to Mr. Burnham indicating that they transferred to South Windsor. Now, you remember, it was supposed to, in the approval, go to a nonprofit agency, okay? But of course, the town of East Windsor knew it was going to South Windsor, another municipality. Not to suggest that municipalities are for profit, but it wasn't entirely within the spirit of the original condition. Somebody does title search, as people do, because you take title subject to all of the conditions that are on title. They discover that the name used in the original quitclaim deed for my client was wrong. And so they asked my client for a correcting deed through his attorney. Attorney Barry prepared this. It just corrected the legal name, contained the same conditions. It's really not a substantive change. Section S is the warranty deed from Scout Hall to the town of South Windsor. It contains all those same restrictions, a legal description, and then in Exhibit B, it says what it's conveyed subject to. Number 1, any encroachment, encumbrance, violation, variation, or adverse circumstance affecting the land that title is disclosed by an accurate and complete survey of the land. In addition, it references the approval, which was recorded on the land records, remember, number 11, as well as the extension as number 14. So now South Windsor owns the controls. Client's really not a party to. My client's really not a party to that transaction between South Windsor and Scout Hall. He really only knows about it because of this correcting deed. So my client is navigating along. Now, this is in 2020 that transfer was happened, you know, trying to navigate the impacts of COVID on the construction industry, building houses, entering into contracts. And then earlier, just this year, 9 years after the client stopped in his tracks. He gets a letter from Coleman and Conley, attorney Brian McCann, which is Exhibit T, which basically says you didn't deed the title over correctly, and we are not giving you any more steals. Now, he mentions, and you could read this, and you may have already read this because I know it was part of the town's exhibits. He does tie in some issues on erosion and sedimentation control and says, you know, talk to the staff. And in fact, about the E&S issues. In fact, Exhibit U is the email that he transmitted that letter to my client with. And he says, of course, you should work with the East Windsor Planning and Zoning Department in order to attempt to resolve any potential or pending sedimentation and erosion control deficiencies. Because that's usually how E&S issues are managed. You meet with staff. It's a constant battle, right? I mean, you've got an active construction site, you got a big rain event, you know, you got a new area open. They're always having to, you know, kind of shore up E&S. Okay. So Exhibit V is an indication that my client has met with Ruth Ann and Danielle on April 11th. So this is 3 days after that email. That letter was actually emailed to him from Attorney McCann. And it recaps that they had a meeting to talk about E&S. It gives 4 enumerated steps that they want my client to take to address the E&S issues. And then it says, you also mentioned the matter of maintenance of Shank Road, because of course that was the thrust of the letter from Attorney McCann. This is being handled separately, and until such time as it is resolved, no bonds will be released, no COs issued. Now, my client is really stunned by this because, as I mentioned, 9 years later, 20 houses sold, 11 permits granted. He's got houses under construction at various stages, several almost ready for COs. He sends it, he immediately writes back. He doesn't understand. What do you mean? That has to do with, he says, the Boy Scouts in South Windsor. You know, they don't want to be part of it. They don't want to be part of it. The planning staff doesn't want to be part of it. They say it's being handled separately. Now, my client had never heard a word from the planning staff about the maintenance of Shank Road in all that time. It is not normal for suddenly you to get a letter from the town attorney with no notice from the planning staff indicating that they're holding you responsible for some condition that was in the approval that you haven't met. That is not how it happens, okay? It's just not a typical situation. So apparently there was some meeting, Attorney Barry participated, the Attorney McCann with the first selectman, Jason Bassa, and the town manager at South Windsor, and his name escapes me, it's Natalia's name. Some of you might know it. It was a virtual meeting. It did not go well. There was a lot of hostility between town leadership, and it did not go well. Okay. Attorney Barry refers the file over to me because it's really turning into a very serious issue for my client. So I write a response, June 5th, you know, after I've kind of sorted through everything before, and of course I take an official position. You're crazy. You're not responsible for Shank Road. The town attorney reviewed it. By the way, that's your partner. You probably didn't know. I mean, I really don't think he knew. Before I sent the letter, I called him up and I said, look, I said, I'm taking this official position. You need a few potholes filled down there or something. We'll go have a site meeting. We'll go, you know, let's talk to us and tell us what we need to do. You know, he doesn't need to go spend a lot of money on, you know, bring an injunction action, everything else. You know, we're reasonable people. We'll talk about it. So time goes by, weeks go by, nothing's happening, we're not making any progress. I tell him we're filing for an injunction. And I did, in fact, and this is tab Y, file an action. You have to, when you do an injunction action, you file it with the court first, you get a court date. I did an actual temporary injunction and a complaint, 4-count complaint, claiming estoppel, claiming declaratory judgment, where we want the court to interpret claims for money damages for torture. Now, at this point, we have not heard anything directly from the town planner or the CEO about enforcement. I sent a courtesy copy of this to Attorney McCann. And so after that, only after that, we got a notice of violation. Somebody realized, well, I guess we better issue a notice. And obviously we appealed to it. We knew the appeal date, the appeal timeline, but we even put it in before the appeal deadline because we wanted to get on the next agenda, which was August 5th. We went a day early, hand delivered, my paralegal, hand delivered. It's not her first rodeo. She's worked for me for 25 years. Got a receipt, made sure everything was in order, made sure it was good so we could get on the next agenda. Okay, yep, looks good. Everything looks good. We do it a day early. So if there's something missing, we can go back the next day with it. So then I receive an email, and all of that's documented here in AA and BB. And I receive an email or a letter by letter from the zoning enforcement officer that says, we think this is incomplete. Can you give us a narrative? And that's not required in your instructions. I looked back at all your notice of violations for the past 2 years. I don't see anywhere that, right? Of course, now this she has sent the day after the filing to get on like August 5th application. She's agenda. She says now it has all the publication dates. You're going to have to go to the next meeting. There's no such. So now here we are in October. We're several months out that my client is sitting here. And ironically, because now there's a notice of violation, this board arguably has jurisdiction to hear this. We would have certainly come to you back in August. We would have been happy to do that. So Attorney Hood files a motion to dismiss my injunction case, effectively just putting off the hearing we had scheduled on the temporary injunction for last week, October 3rd, because he does it right before, a week or two before our hearing. We know we can't get heard and cited by then, so they have to go for the ZBA first. So there's been a lot of kicking the can down the road and trying to delay this and put maximum pressure on my client. So I had a site plan visit planned with Attorney McCann, and it was for July 19th. We'd spoken to the town engineer to try to get a little information. I fully expected the planning staff to be participating. 2 days prior, Attorney McCann said he had to cancel it altogether because your first selectman, Jason Bowser, had a personal matter come up that he couldn't attend. So fine, things come up. But it begs the question, why is the first selectman an essential party to a site visit on a zoning issue? It doesn't make any sense, okay? And the reason is because he is driving this. He is making all the decisions related to this, not the planning staff, not the town engineer. And despite requests, they would never reschedule the site visit. In fact, to this day, we still don't really know what the town wants from my client. I think what they want is my client to commit to maintaining the road in perpetuity, which is not going to happen. We'll try the case. I mean, the judge wants to tell us that, fine, but we'll try the case first. The notice of violation is signed by your zoning enforcement agent officer. She's your agent, but she is definitely not the one orchestrating this, nor is any of the other planning staff. They are taking these instructions because they all like to be employed, okay? And I will give some credit to whoever actually drafted that notice of violation. I'm sure there were many fingerprints on that because they did try to tie it in with the ENS and make it look like a legitimate zoning issue. I do want to state that there have been some photographs submitted by the town, and they stated they were from July 2024. They said this was Exhibit 12. They showed a lot of puddles, and they called them flooding on Shank Road. They were actually taken July of 2023. And I have confirmed that with Ruth Ann, who's here, and I'm sure she can confirm that for the record. That was an error because there wasn't even a rain that day. It wasn't even a rain event that day. That's how I realized it was an error. My client thought it was. I looked back at climatology reports that we got it for that day and for July of 2023, which was the only prior time in 2023 that the town staff had even contacted my client about ENS issues. Legally, we do have numerous claims. Obviously, this board is not going to hear all the legal claims that we have. But the delay tactics that have been used to put maximum pressure on my client are really a double-edged sword for the town. We put the complaint together quickly. Actually, most of it occurred over a holiday weekend. Since then, I found 2 federal cases that say specifically that withholding COs is actually a violation of property rights because your certainty is so significant when it's a CO as opposed to a permit, and a potential violation of Code 1983. You know, we can certainly amend our complaint to add this. Clearly, the longer this goes on, the more the risk increases. And I understand it increases for both sides. You know, my clients, you know, a small business owner, maybe you call him a mid-sized developer, you know, he can't sustain this forever, but he's not going to go away either because he has a lot invested in this project. It takes years and years for developers to start turning profit. He's nowhere near that yet. And he has commitments to a lot of property purchasers that he signed contracts with. As late as last week, actually, Attorney Hood told me that I should get South Windsor to somehow start maintaining this, as if it's our responsibility and we have any right to do that. Who would have leverage to do that? Maybe your first selectman, maybe your board of selectmen, maybe they can take some action there. That is a role that he should be playing, right? He's like a chief executive officer. He is not a planning person. You rely on your planning staff. They're agents, they're knowledgeable, they're skilled. You are all elected. And so are the Planning and Zoning Commission members. You are the ones who are supposed to be making the land use decisions for this town, not the first selectman. And they're supposed to be done at public hearings, which is the process that is established by statute. Now, I will tell you, without disclosing the details, at our first court appearance on this, we went before Judge Graham, who's been on the bench at least 25 years. I don't know how long. He said, we can try to mediate this case. And that's like an informal settlement discussion. And obviously it didn't end successfully or I wouldn't be standing here. But, you know, he's very sharp and he said, well, you know, East Windsor's obviously asserting maximum leverage possible by withholding the COs. And eventually, when our conversations broke down, he said, the town is holding a gun to the head of the developer. And if the court takes the bullets out, the town gets nothing. You know, experienced judges speak very candidly to parties. Doesn't mean we're going to win the case. Doesn't mean anything. You know, he was kind of giving us, obviously we got to put all the evidence out and everything, but it's very difficult to settle with municipalities because they are not spending their own money. They're spending the taxpayers' money, right? My client, who has a family at home, is paying for all this out of his pocket, and this has put a tremendous strain on him financially. You can end it here tonight because really my client just wants to move on from this situation. If you sustain the appeal. Now, you're acting in a quasi-judicial capacity in determining this. You're not determining if my lawsuit has any merit. The E&S issues have been taken care of. And you're going to hear from my client. You're going to hear from Dana Steele, who's been out there again recently. Nowhere in that notification, notice of violation, does it say reinstall silt fences, stabilize the berm, all the normal E&S issues that come up, okay? We can't rewrite the approval. No one's going to rewrite the approval from 2015. The court's not going to rewrite it. They're going to just interpret it. If this was an issue, it would have come up in the past 9 years. They're strong arming my client, and it's a massive overreach. You know, did the planning and zoning make a mistake trying to trusting Scout Hall to do the right thing and glossing over it? I don't know. Did the town attorney and the planner make a mistake when they reviewed the deed? Maybe. Did the Board of Selectmen make a mistake when they allowed the property to go to South Windsor without insuring this? Maybe that's the motivation for this. Maybe they're embarrassed that happened. But the situation is that my client can't fix the situation. He can't go back and rewrite history. He doesn't get a do-over, okay? And I know this appeal can put some of you in an uncomfortable position. You know, making a judgment like this is very difficult. You need to trust your planning staff, and especially your zoning enforcement officer, who's your agent. That's a very important relationship, and I don't want to try to undermine that, but this is not coming from your planning staff. This is an attempt by the first selectman to bully my client to taking on responsibility for this road. You're an independent board, elected officials, you know, to take directions from the first selectman. Your responsibilities to the taxpayers. If I were a taxpayer in this town, I'd be pretty unhappy with this history. You know, allowing the notice of violation to stand will have real consequences for those taxpayers. First of all, my client has 11 houses that are, you know, ready to be completed, approved in short order with COs, and start generating tax revenue, about $8,000 a year. You're paying legal fees to defend this lawsuit. And you've got possible exposure for monetary damages and maybe award of our legal fees for 1983 action. So with all of that, I'm just going to ask you all to vote with your conscience. You don't need a law degree to understand that this situation really doesn't smell good. You know, I trust you all to just think for yourself. You've seen a lot of dark documents. You've listened to me, and I appreciate you sticking with me and listening to all of this. I appreciate how attentive you are. I know you're going to hear a lot more, some of which I can't admit or deny from some residents in the area who have their own opinions. Some might agree with me, some may not. I will just mention, I didn't want to kill too many more trees, but I did submit some additional exhibits without copies for all of you. Those consist of basically photographs, which Dana Steele took, which we can go over, as well as photographs that my client took. The detention basin as-built, which I mentioned, was from 2017. Excerpts from your charter that discuss the first selectman's actual role and responsibility for this town. Planning and zoning minutes from 2020 to 2023 with various references to West River. Some said, looks good. Some talked about reducing the bonds. The 2023 referred to some E&S issues, which are definitely documented in your exhibits. Beginning in July, there were some heavy rain events. I actually mentioned several subdivisions that were having serious water issues. And then a couple more meetings go on, November 23, looks like it's all cleared up. So just continuing to monitor. Nothing since November 2023 on E&S, nothing. 2024 minutes of all the planning and zoning commission meetings, and forgive me because I put them all on your record. You don't have to read them, but we sometimes have to prove the absence of something by putting all of it in. Some of them are draft minutes that aren't even finished. No mention of West River until September 2026, and which say they're kind of updating them on West River farms. No E&S issues, but somehow this notice of violation goes out. The town staff updates the planning and zoning commission periodically on projects in town. It's an essential part of their function. An essential part of the zoning enforcement officer's function is not to rewrite an approval. And I think you can all understand that. I also put in those 2 federal cases that I mentioned in the record. And we just always have to build our record in case this ends up in an appeal, unfortunately. So thank you for listening. I am going to have Mr. Steele come up and give a quick presentation on his findings of the site review.
Thank you, Attorney Gallagher. My name is Dana Steele. I'm a professional engineer and principal with J.R. Russo and Associates. Our office is at 1 Showham Road here in East Windsor. I am the engineer of record for this project. I prepared the original design plans for the project, including the erosion control plans. Those plans were reviewed by your town attorney, approved by the Planning and Zoning Commission, And I also prepared the bond estimates for the erosion bonds that were also reviewed by our town attorney and approved by planning and zoning and established for this project. And the erosion control plan and the erosion control bond together serve as a maintenance agreement with regard to erosion controls for construction projects. And so I believe that the town has the provisions in place to control erosion for the site. I did review the photos that were submitted by staff, which showed some sediment-laden waters in Shank Road, showed sediment silt fences that were breached and had not contained the sediment. So there is record of some issues with erosion on Shank Road. I went out last Tuesday to take a look at the road in its current condition. I found the road to be clear and clean with very little sediment. There was some tracking of sediment at the end of the road, but that was not from this development. It was from the East Windsor Auto Parts, which has a gravel turnaround area. And so there's some tracking for that. So when I took a look at the erosion control measures along Shank Road, I noted that there were silt fence, double rows of silt fence. There were straw wattles in place. And what that tells me is the developer's contractor has been progressively working to reinforce erosion controls. Obviously, there was some issues with erosion controls, which is common in construction projects. And the thing about erosion control plans is they're a little different than most of the plans in a plan set. Most of the plans, whatever's on the plan, that's what you have to build, right? But erosion controls are different. Erosion controls, the plan is sort of a bare minimum. You need to do at least this much. And in part of the erosion control plan is built in an allowance for the town to require additional erosion controls. And so if additional erosion controls are needed, then the town can, through the town engineer or through the staff, can say, hey, we want additional erosion controls. We don't think this is adequate. And there's a process for making sure that takes place. So I think that the town has already has the ability to control maintenance with regard to erosion control during this construction project. My opinion and conclusion, having looked at the site last Tuesday, is that they have appropriate erosion controls in place. They're being appropriately maintained at this time, and there are currently no erosion issues on Shank Road. No significant sediment deposits on Shank Road. So thank you for hearing me, and I'll remain here to answer any questions that you have. Oh, I did take some photos that were submitted showing the silt fence along the end of the berm. So as you come in Shank Road, you'll notice there's a vegetated berm along the side of the road. Once you get to the end of the road, though, the berm ends, and then that's where the erosion control measures are in place. Silt fence, straw wattles, and so forth. And so there is those measures are in place. I took some pictures on the backside where you can see there is still some sediment deposits on the uphill side of those measures, which means that it's doing its job to contain those. And those haven't yet been cleaned up to finalize this, because it's still an active construction project. So you can see there's a photo of the road. There is some dirt in the road, some tire tracking that said those appear to be coming from South Windsor Auto Parts. Took a picture. There is a little bit of sediment along the edge of the road in a couple of spots I zoomed in to see, but nothing significant, nothing that would be in any way impeding the access of Shank Road or the ability to maintain it. So in my opinion, it was not significant. I think that's all I have. Thank you.
So Attorney Dave Berry, as I mentioned, is Lenny Jacobs' partner, and I just wanted him to verify the legitimacy of the documents that we have submitted from his office.
So yeah, exhibit J and K, I believe, are the email correspondences from either Len Jacobs or Michelle Villanueva, who's here in my office, to Diane Whitney and to Lori Whitten. And the markups, which we believe to be from Diane Whitney, based on the email correspondence. These were found in our file.
Can you explain why Attorney Jacobs cannot be here?
Attorney Jacobs, who retired in 2017, has unfortunately very advanced Alzheimer's, so we can't testify. Yeah, no problem. There were a couple of comments, as you'll see in these emails from Diane Whitney, with saying, yes, the deeds look good. And then there was one thing, oh, I forgot, Shank Road is misspelled. So you'll see, though, her comments are right on the deed.
Sure.
And then also Michelle from Attorney Berry and Attorney Jacobs' office, who was the paralegal who actually transmitted these items. Just for purposes of the record, section tab J and K. I just want her to state her email that she knows whose handwriting this is in the deeds.
In the quitclaim deed, I don't believe that's anyone from our office that came from outside the office. I've been there 23 years. I pretty much know everyone's handwriting in the office. And I know that didn't come from our office. And I was the one that transmitted between myself and I worked very closely with Attorney Jacobs.
And Attorney Bowen, who's my client's closing attorney, some statements to us.
Evening. As Bridget said, I am Attorney Bowen. I've been working with Jeff as his residential closing attorney for over 12 years. Over the last couple of months, I fielded calls from realtors and attorneys who are representing purchasers of the homes that we're discussing here tonight. They voiced concerns over the litigation, town's refusal to issue certificates of occupancy, or even provide a timeline for issuance. Building and moving to a new home is already one of the most stressful events of people's lives. Litigation and conflict surrounding it is creating further stress and anxiety. In some cases, additional costs, not only for Jeff, but for the prospective buyers who cannot confidently create a plan to purchase and move into the homes here in East Windsor. Often the actual purchase of a home is only one step in a series of dominoes, and the delay here has consequences past this room. Purchasers often research multiple builders based on reputation and quality. Jeff has built a reputation as a reliable builder who tries to go above and beyond to give purchasers exactly what they want in their home in a timely fashion. Purchasers make plans to move money around from various assets, including investments, retirement accounts, sales of current properties, or obtaining financing. Their timelines and the costs associated with this. Appraisals, credit documents can expire. There are penalties for not adhering to other timelines. Subsequent buyers of the West River buyers may also be delayed in their purchasers, as well as additional storage and rental costs while the purchasers are waiting to actually move into their homes. Additionally, when purchasers go through the process of building a home, they design unique features of their home, which Jeff immediately starts to work on and order materials for. Purchasers start to pay for these unique features immediately. If Jeff cannot timely close on a home and purchasers walk away, Jeff is left with a home with expensive upgrades that he may not be able to recoup because of the unique design elements. If this conflict continues, COs are not issued, there are further delays, there will be harm to Jeff's reputation, which he has spent years, if not decades, building, and creating unfair and undue cost and anxiety for Jeff, as well as the purchasers of these homes and future East Windsor residents.
And finally, my client would like to get up and speak to. And I think I misstated. I think I said my client sold 20 houses. He's actually sold 24. I think it was 20 in phase 1 and 4 in phase 2. Okay. That's why he's here. That's why he's here. Okay, and he does have photos as well, which he or one of his staff people, one of his employees too.
So, as Attorney Gallagher mentioned, I never heard anything about the maintenance of Shank Road. From the time I started this project, and as a matter of fact, even during the meeting minutes, I said, we can't take on responsibility of Shank Road, but there was never, since the approval, at any one time, that I was responsible for the maintenance of Shank Road before I got Attorney McCann's letter in April of 2024. Been working for 9 years. I've been spending millions of dollars of infrastructure. I've never been told once. I've sold 24 homes, built 24 homes. Never once has there been an issue about the maintenance of Shank Road. Yes, there's always a battle with erosion control. And you got to remember, we open a site up and it's all mud now, it's dirt. And there's a huge rainstorm. The mud will start to flow. And we have to try to stop it as best as we can. We put up silt fences. There was some discussion with the silt fences. I think the town staff can accurately say that every single time they brought up an issue to us, we jumped on it. We never, ever ignored the town staff. We always jumped to take care of it. Matter of fact, we'll go through it, but we met with the planning staff on April 11th to address the email about the erosion controls. We explained everything we were doing on the site. They wanted additional measures done. Specifically, once the foundation, and there's a letter that was encapsulating what our meeting was about. Once the foundation holes are excavated and soil stockpiles are established, they'll be ringed or horseshoed with a silt fence. In other words, once we dig out, the hole, the mound of dirt that's there, we'll ring it to make sure that mud doesn't go anywhere until we put it back into the ground when we backfill the foundation. They wanted a second row of silt fence to be installed at the top of the slope, not only just at the bottom by Shank Road, but they want it on the top of the slope as well, parallel to the silt fence at the toe of the slope along Shank Road. Pictures here will show that we have double silt fences that was put up. Right after that, as was discussed, first we had the bottom ones redone, because after a while they get knocked down, they get ruined. But there's a huge, if you remember in 2023, there was never a normal rainstorm. It was always monsoons. Town staff said they were running all over town about water issues. So it wasn't just us, and these silt fences can only hold up so much mud that comes down before they got knocked down, and we have to redo it again. We have to fix it. We have to clean out all the mud. We got to take care of it, which we've done every single time. They've asked us to redo this one immediately. We did. They asked us also to call them. Every single time we put a silt fence in place around the new foundation, we called them every single time. I don't know if they came out or not, but they said, thank you for the phone call. I don't know if they came or didn't come, but they were all there and in place. Once we were backfilled and once we were able to, we put that extra silt fence along the top, as you'll see in the pictures, to give it double erosion. Not only that, but in order to make this site grow grass, right in between the two silt fences, which is a hill, we went out and spent $5,000 in hay mats. I don't know if you know what those are. Those are special mats that are put on hills that usually is done by municipalities because they're expensive to install, and they're pre-seeded. And when it started to rain, it will first of all stabilize the hill by having these mats pinned into the ground to stop the mud, and also will allow grass to grow on hilly areas. So we spent $5,000 and put a couple of, let's say 500-600 feet of these mats all along this entire area where the slope was great in order to have the grass grow on the slope. So we did everything we possibly can. Again, staff, every time they asked us to do something, we jumped and did it. We've been working there for 9 years. Never once did we have any issue. And never once was it mentioned anything about a maintenance agreement on the road. And just to add about this deed with this word maintained access or continued access. It was our understanding all along. I can't talk about staff and all, but it seemed to have been their understanding as well. They were concerned that the residents should still have access to that road and get into their homes. That's what it was. It was never about a maintenance agreement. Maintain access is a noun. Maintenance is a verb. Maintenance of, and they put it in the same sense. Well, since it says maintain access to the road, therefore you have to do a maintenance agreement on Shank Road. Maintain access for the residents, therefore you have to do a maintenance agreement on Shank. What does the maintain access for the residents have to do with the maintenance agreement on Shank Road? And I think everyone understood that, and that's why they signed off on maintained access, because that was what the understanding of what that was. And again, the town had every opportunity to have Scout Hall. Scout Hall never took care of this road. You know, they never maintained it. It did South Windsor. When it came before the town, when South Windsor was going to sell it to, when Scout Hall was going to sell to South Windsor, East Windsor at that time, if they felt that there was something lacking in the deed, they could have taken that road back, fixed the deed, and then sold it to South Windsor by writing that there should be a maintenance agreement. As you know, we had a 7-page approval that detailed everything that had to be done on the site in detail. And it's something as important as plowing this road, maintaining the road, asphalting the road, fixing potholes on the road. You don't think that would have been detailed? 4 or 5 words, maintain access for the residents, is supposed to mean all of that? I don't think so, and it was never the intention. And that's why we were operating under that assumption. The planning and staff was operating under that assumption. The town attorneys were operating under that assumption. And we were as well for 9 years. We asked the court to please.
I'm gonna pass around these photos for the board to look at. So my client also has the site contractor, various other employees here. If there are any questions, we'll all remain here. If there are any questions, obviously. Ruth Ann, if you would just for the record, you can confirm that those photos were in fact taken in 2023, the ones that were.
Oh, yes, yeah, the exhibit 12. When you called me, I got a hold of the town engineer and he gave me the right date. And I said, well, send me your pictures so I can cross-reference them. And so his pictures were of really the quality of the road. Like we went out there to assess the road and it was dry. So Danielle looked up her photographs. So the photographs in exhibit 12 are actually from July of 2023. They are photographs that Danielle took.
And again, the photographs from 2024, this town engineer took in July 2024, shortly after the notice of violation, is dry as a bone. I didn't print them because I received them after. Okay, dry as a bone. There's definitely no erosion issues going on there. You know, and my client makes a very good point. You know, there was no requirement that my client put in drainage facilities in Shank Road, that he paved, that he do anything. They didn't want him to really touch it, was my client's belief. And I can tell you one thing, you can look at that approval all day long. You will not see anywhere that is said my client has to submit a maintenance agreement. That if somebody wants a maintenance agreement, the Planning and Zoning Commission, you can bet very specifically put it in this approval. Thank you.
Thank you, Counselor. Does anyone on the board have any questions? Yeah.
Gallagher, based on what your client just said, is it the belief that your client never had responsibility to maintain access on Shank Road?
Well, I think if you mean when my client died, my client was the owner. So my client was the property owner at the back, up the property at the very end, right? Once he acquired the property. And so if he wanted to access that property, this is where the geeky lawyer in me comes out. He had to, you know, obviously if there was snow on the road or something, he would have to clear it in order to actually access that property. But no, he did not have a legal obligation. There's nothing in the land records that he had any kind of maintenance obligation in the land records. And statutorily, and I can submit the statute from the record too, just probably 15 years ago, there's lots of these little private roads to shared driveways. Lots of them don't have any kind of maintenance obligations that are spelled out, especially the older ones, they're one sentence. And so about 15 years ago, our legislature finally passed a statute that said that if residential properties are all benefited from a common road, that is a private road, they have a joint obligation to maintain it. That does not apply to non-residential properties, and it does not apply to municipalities. So it did not apply to South Windsor either. And I will submit that for the record.
So I know we're going back to 2015, but, and I can look back at the minutes, although I don't think I saw anything. There were a lot of conditions.
Yes.
And wasn't there discussion on your part about what those conditions meant, every one of them, and what it meant for your client, your client?
Yeah. So I wasn't involved. Attorney Isaac was involved, and unfortunately I've heard he's not in a position to, to speak to that.
Okay, thank you.
Who actually currently owns Shank Road now?
Town of South Windsor.
Town of South Windsor, okay.
Is the erosion on any of the new construction or future construction a concern? I mean, do you do maybe like a 3-tier type thing, or just to keep any mud or anything washing into that street in future building, or are you kind of done with that future building? You know what I mean?
Yeah, I think so. So I think that your question is, when my client moves on and starts building more houses,
Yes.
that might be upland from Shank Road. Is that basically your question?
Yeah, because I'm wondering looking at the photos, it looks like some of the elevation isn't as extreme.
It is extreme.
And then some doesn't look like it's too bad, but it looks like it's been kind of addressed, but without me seeing it, I can't really.
Yeah. So, and that is part of what the town staff had asked my client to start addressing in the future, because they had that issue in 2023. That's Exhibit V, where she said, put a horseshoe, like put a silt fence all around the site when you're digging a hole for a foundation, so that all that earth does not move down the hill, right? So all of those types of measures are taken as they go along, as they start opening up a site. So, so you're correct. So there are some lots that are going to be above Shank Road. I'm not sure which are developed and which are not, but those measures have to be put in place. And as Dana Steele stated, you kind of work as you go on these things. And they work usually very closely with the town staff in terms of what measures are needed. And sometimes you do have a really significant rain event. I mean, we have all experienced a lot of those in the past few years, and they make this a little bit more challenging. It's an active site. They have to constantly be monitoring those things.
I'm just asking, Shank Road was in existence before this project started, correct?
I think it's been in existence well over 100 years.
Yeah, now it's not paved. Looks like it's.
There's some pavement on it. It's not in great shape. But there is pavement.
It's been used and people are using it, especially the ones down, I guess, at the bottom towards the Scantic side.
Yep. Yes, it's been in use. Presumably all those individuals knew they were buying a house on a private road, or, the Shank family, I think, probably must have owned all of that at one point and carved it out and sold lots. And, everyone there bought on a private road. Unfortunately, the statutory obligation falls on them. But now to South Windsor, that statute does not apply to them because they are not a residential property.
I just wanted to kind of understand some of the layout of the land, if you would.
So you had mentioned that, if there were any minor issues with, Shank Road that you guys, like a pothole, you guys would fill it. Have you guys done that at any point, to help out to be, I'll start with that one.
Sure. So a few things have to happen for us to do that.
Okay.
One, we need to actually meet with the town and have a site visit and have them show us what they want. Town engineer might be a great person for that. Two, we have to actually get permission. Now, we don't own it anymore, right? So we have to get permission. I don't think South Windsor is going to object to this road. But there's also, we'd have to be very sensitive to the residents of Shank Road because they're very concerned about their own improvements. You know, they have property rights there too, including the right to ingress and egress, you know, that was established when they built it.
The other question is, obviously it's been a long process, over 9 years, I believe you said. Has there been any violations? And if there has, how were you notified? And how long did it take to fix the issues that might have been brought up?
Well, let me have my client answer that because I'm
Sure.
new to the party here. I just.
Okay.
Here.
We never have.
Never had a violation, okay.
I just want to add, we've done everything we can try to work with them. There's a neighbor, as a matter of fact, we got a phone call from town staff that a neighbor on Scannick Road had a little farm stand that's in between our two properties. No chance to help me. She's 85 years old. She was saying that, you know, as water now, they made a new road on Shank Road. And in the future, you know, the water runs past her house on Shank Road. And it's flooding her farm.
Right of way.
So we went out on our own. She has to help us when we had an asphalt truck there, and the town said some of the water might be coming down the hill from our property. So we went in there and we asphalted aprons for her to keep all the water out. When we were on phase one, it was the big hill behind the homes in phase one. It wasn't required, and I can tell you, there was a tremendous amount of water coming down the hill. There's a berm in the back of the property made to catch the water and bring it down to the front to go into the storm sewer system. But you know, sometimes in these huge monsoons, it fills up really quickly. And yeah, after the rainstorms, it all goes back down again and works properly. But during these monsoons, it's just too much water. So we actually put in a catch basin right in between on our own, $10,000, put a catch basin in and connected it into our storm sewers to alleviate this going on. The town of South Windsor called us, and it wasn't in our approvals. You know, they said that we built the drainage system along Shank Road. They said that the water, Shank Road goes downhill. So during these monsoons, the water was rushing down that road and eroding a little bit, going into South Windsor, to the back part of the property. They asked if we can do them a favor and put dams in. Dams are, structures that you put in made out of rocks and whatever to slow the water down. We did that as well. So anytime we've been asked to do something, we went beyond what we had to do. We didn't have to do this for, but she's 85 years old. She's an old lady. She asked us to help her out. And the town appreciated it. We did it.
Thank you.
Anybody else?
Has the road ever been, lack of a better word, like destroyed or despaired based on any of your construction?
We're the closest 150 feet, 200 feet.
Yeah, it looks like you got a pretty decent.
Pretty close.
Yeah.
We have homes in between.
Yeah.
It's right like 150 feet from our road to that.
Thanks.
I do have a question though. I have a question for you. In the notice of violation, so it seems to me like what the town is asking is for Shank Road to be maintained as an access for residents. Are they asking for you to maintain the road year round, plow, fill potholes, or keep it open as a right-of-way easement to get to the back lot? It seems, as a lawyer, I mean, what is the definition of be maintained as an access for residents mean?
So the notice of violation And that's an excellent question, because we really, still to this day, don't know exactly what they want. But I think what they want is my client to agree in perpetuity, long after he leaves this,
Yeah.
to be responsible for this roadway. And that, my client purposely spent extra money to do a subdivision. It costs a lot more to do public roads, to build them to town specs, because it's more attractive to his buyers not to have an association. If that obligation got stuck on him, he would have had to pass it along back in 2015 when he started selling houses. He would have had to do association, pass that cost along to his buyers. He wasn't on notice, but as you see, it does say what they want him to do. The one step, right? That enumerated step, number 1 on page 2. One step he's ordered to take. Submit an appropriate and acceptable maintenance agreement for Shank Road.
Right.
There's no requirement in the approval. It's absent of that requirement altogether.
Thank you.
Okay, thank you, Council.
Okay, and I am going to just submit for the record that statute I referenced earlier is Connecticut General Statute 47-42F. It applies just to residential properties, as you'll see right in the initial definition section. And it was actually passed in 2014.
Great. So we will now move to the presentation on behalf of the zoning enforcement officer.
So if I may, just, as the counsel for Danielle and the CEO, I'd like to clarify just a few points and respond to a couple of issues raised by Attorney Gallagher. If you prefer, I could go up or I could stay here, to whatever.
I prefer you to be.
Absolutely. And then Danielle will make her presentation. So again, I'm Ron Hood. I represent Ms. Boudreau as the zoning enforcement officer on this action. I wanted to clarify a few points, answer some questions preliminarily. There was a suggestion, well, first I'll say, as far as the litigation goes, it's obviously a separate, distinct matter from what's being decided here tonight. But my representation of the town in that action is pursuant to the town's insurance policy with KERMA, and it's being paid by KERMA. So whether that action goes on for months, days, the cost of the town isn't increased. But so to go back, when we were talking earlier about the idea of transferring this open space to a viable entity, it was suggested that maybe the town was trying to avoid some responsibility, or that East Windsor didn't want this public space or this open space for some reason. And the true reason was because the developer was seeking a modification of the bulk and area requirements for the subdivision. And there's a regulation that I didn't bring up with me, but I think it's cited in the notice of violation, or probably additionally in Attorney McCann's letter from earlier this year. But there's a citation to the regulation that allows the modification in consideration of transfer of open space to a viable nonprofit entity who will maintain space and allow recreational use and other things as defined in that regulation. So this wasn't the town skirting some responsibility or trying to avoid responsibility. It was a modification of the requirements that the developer was seeking, and they found a reasonable alternative under the regulations to do that. The suggestion that the conditions fell specifically within the permitting phase of this, the original conditions of approval, that somehow, because the permits have been issued, that now those conditions don't matter. That just can't be, because the permit is still active, special use permit is still being used. They can't just complete a condition and then the next day turn around and undo those conditions. They are effective, I would argue, in perpetuity, but at the very least, while the permit is still active and they're still doing construction and building the subdivision under that permit. The process that brings us here tonight is not typical. I understand that. I don't think violations in general are very typical of many towns. But there's nothing that was improper or in violation of procedure or statute, or anything that violated due process or anything like that in terms of how this violation was issued and when it was issued. There's been a bunch of mention about South Windsor. I don't know if they're here tonight, represented tonight, but they're clearly not part of this specific violation. They are the owner of Shank Road as it currently exists. But your job tonight is not to decide what South Windsor's obligations are, or what responsibilities they have as to Shank Road. Their responsibilities and their obligations and any legal defenses that they may have will probably be raised at a later date. They're to be determined. Town has been in discussion with the town of South Windsor. It's not as if they're have no involvement in this process at all, but the obligations of West River Farms and the obligations of South Windsor are two separate and distinct issues. The developer or the applicant keeps coming back about the erosion controls. There's been a lot of pictures submitted about the effectiveness and measures that were taken to correct certain issues with erosion and flooding and how it's affecting Shank Road. To be clear, the town isn't challenging those measures that we're taking or the effectiveness of those measures. In fact, the zoning or the erosion and sedimentation controls are not the issue that was laid out in the notice of violation. They are precipitating. They've brought to the town's attention the failure of West River Farms to adequately address the maintenance of Shank Road, but they're not the issue. So whether you think the controls are adequate or not adequate, it isn't really what we're deciding here. The notice of violation references a remedy to this issue, and the town hasn't asked West River Farms to maintain the road in perpetuity and to take all responsibility back and plow and repave and do that for now until the end of time. The town has asked West River Farms to submit a maintenance agreement. That doesn't need to be an agreement that they're even party to, but that while they are still in control of the process, building the development, they have some ability to negotiate with parties, whether it be South Windsor or some other entity that maybe deeded the Shank Road and open space. They have the power to suggest, negotiate, try to get somebody to accept that responsibility for maintaining the road. Obviously, town couldn't say, well, go back in time, rewrite the deed to Scout Hall, have them rewrite the deed to South Windsor. It'd be impossible, right? But what has been offered is a reasonable solution to an ongoing problem that, if left unaddressed, will just get worse and worse, and eventually the road will be completely disrepaired. And finally, there's been a reference to 9 years. 9 years this has been going on, so 9 years since 2015, and now all of a sudden this is being raised. Well, it's not all of a sudden, because there were two precipitating events, one of which I've already talked about, and that was the failure of the erosion and sedimentation controls on the property, which brought to the town's attention, the zoning officer's attention, that the road is being affected by the construction. There's flooding, there's sediment, there's issues that are accelerating the wear and tear on the road. And lo and behold, nobody's maintaining the road. And as referenced in the exhibits, you saw that East Windsor Scout Hall Building Committee worked with the town, worked with West River Farms, submitted a memorandum of their understanding of what the maintenance would be and what they were willing to do. And that went on for several years. And in 2022, when East Windsor Scout Hall Building Committee didn't want to continue to own the open space in Shank Road, they transferred it to South Windsor. And when South Windsor took it, things changed. They interpreted the language in the deed differently than East Windsor Scout Hall Building Committee did. The language in the deed said not to maintain access, but to allow access. Again, Scout Hall took that to mean, yes, there's a maintenance obligation. We're going to work with the residents. We want to come to an understanding that everyone can agree with and continue to maintain the road and provide meaningful maintenance. South Windsor didn't do that. So that was a significant event in the timeline in 2022, along with the failure of the erosion, flooding, and the other issues on the road that brought this to where we are today. So I'm going to let Danielle now present her side of things, and I'll be available as will she after for questions.
So, Attorney Gallagher did a great job of thoroughly presenting a lot of the same exhibits we have with minutes and letters and references to erosion control as to the other people that spoke. Attorney Hood cleared up some technical issues. I'm not going to read this very large memo, which is basically reiterating everything that's been said. I'm going to give you the nuts and bolts summary of how this violation came to be, which is what we are here deciding tonight is whether or not the violation is valid. And I had received for months and have since I've been zoning enforcement officer almost 3 years now, complaints about erosion control as we've discussed. But recently in this past year was more and more about Shank Road, which we discussed erosion control measures with Mr. Rustler and his team. Yes, they did. They came and took care of that, but that also brought to the attention of us, the maintenance of Shank Road in general, because we were getting phone calls for that. We're getting phone calls about the potholes and the knotweed. And quite honestly, I didn't know how to answer their questions. In my head, as you said, yeah, South Windsor owns this. So I call South Windsor. We're not responsible for the maintenance. So this started an entire collaboration process between the staff of the town, the planning department, the town engineer, our legal counsel for the town. And through this collaboration was where we went back to the beginning and we found this section 8, subsection 2 of the conditions talking about how it was worded was the maintain access to Shank Road. I mean, maintain access. Okay, sorry. No, I don't have some. Sorry. Anyway, it was the maintaining access. You can't give people access to a road if it's got potholes and covered in Japanese knotwood. So I guess in our thought process, that's something that kind of goes hand in hand. And through that, it was advised as part of this process that a notice of violation needed to be issued, which is what we did. It said, start at the beginning, let's get some kind of agreement as to what's going to happen for the residents on Shank Road. And that is where my violation came in. Special use permit runs with the land. So this special use permit specifically stated about the maintenance or maintaining access to Shank Road. And for us, we went with the special use permit that was originally issued. And that is where the notice of violation comes in. So to reverse this order, it would negate the hard work, the efforts of research, the collaboration that the town put in when not only issuing the special use permit, but trying to get to the bottom of how exactly our residents of Shank Road are going to be taken care of so they can actually have access along that road. And to uphold the order would tonight hold West River Farms responsible for the maintenance of Shank Road. And it would be fulfilling obligations that were actually accepted under the conditions 8 subsection 2 of the special use permit that runs with the land that was issued back when this whole project started.
I have a question.
Yes.
On the memo, I think it's the one that you have there at the bottom. It says, at the time of the special use permit application, West River Farm owned the right of way known as Shank Road. Is that accurate? They own the road? I know it's right of way, which usually always meant that the adjacent properties owned a center line, but it could be county to county or state to state, but.
Attorney, do you?
I believe it's the exhibit that was submitted with
On this one?
no, but with the applicants.
That's on the violation that it says on the memo with the violation, it says West River Farms. own the right of way known as Shank Road and the open space at the end of Shank Road?
Right, and I think that's correct. That green area is shown on the map that was submitted with the applicant's application.
Because it's a right of way road. The right of way? Not a town road,
It's not a town road.
the right of way.
Private.
So it's owned by the residents on Shank Road and I believe by the houses that are adjacent on both sides.
It's not a town road, to be very clear.
But a town road, okay, I'm all set. Thank you.
There's no access from his property to Shank Road on the back there, is there?
In the back, I believe there was plans for a walking path.
But not like not a driving path.
Got it. Now that's, now, I think it was changed.
Further questions?
Well, I have a question for Attorney Bush. It's about this question of perpetuity, about special use permits. I'm just not clear as to whether, special use permits do exist in perpetuity.
Well, because this special use permit was recorded on the land records, it runs with the land. So those conditions run with the land. So as long as the land exists, those conditions are valid and enforceable.
Even if it's been transferred, so that's not relevant, if it's been transferred to another entity.
No, because within those conditions, there is there's language that those conditions are binding on the applicant, the landowners, and their successors and assigns. So not one or the other, but all of them.
Okay.
I think we'll save it for comment.
Can you just explain the maintenance agreement one more time? And what exactly you're asking the applicant for?
So I think the exhibit that we submitted from East Windsor Scout Hall memorandum. Not that that's a maintenance agreement, but that's a good example of what we're getting to. So we're looking for the applicant to submit the same to foster and encourage South Windsor to enter into an agreement, or whoever the land ends up becoming. If South Windsor decided to transfer it to someone else or to transfer it back to West River Farms, they could certainly do that. But we're asking West River Farms to facilitate some agreement as to the maintenance obligations to Shank Road, which I believe they have the power.
I believe that they actually have to based on the special permit.
Right.
Yeah, okay.
Yes, based on, again, because they can't go back in time and rewrite the deeds, which change the language of what was in the original conditions of approval. We've proposed a reasonable alternative, which is to submit a maintenance agreement so that Shank Road will be addressed.
Are you referring to the deed from West River Farm to Scout Hall, where it spells out Scout Hall is responsible for the road?
Right.
And then, and then when it went to South Windsor, there was no mention of who's responsible for the road. That's the one you're referring to?
No, it's the same.
So now you're going back to calling out West River Farm, that seeing Scout Hall never passed on the burden. You're going back to the previous owner?
No, we're saying that West River Farms did not correctly pass on the burden to.
It was in
Scout
the
Hall.
deed.
Right, and that deed language was the same as it was from West River to Scout Hall, as it was from Scout Hall to South Windsor. And the language that was used,
I don't think it is. But
well, other than
Go
the
ahead.
name of the entity, the language that, the pertinent language that was used was that shall allow Shank Road to be used as an access.
Right.
Versus the original condition of approval, which said that Shank Road be maintained as an access.
when it went to South Windsor, it states that it shall be used as an access to the residents on Skank Road. Not as originally as East Windsor residents. So it got changed a couple different ways. But
We're maintained.
okay, okay. So,
Is everybody good?
The photos that were supplied in the packet with the violation, I noticed that there were no dates on them. I know that previously there had been. And was that like after heavy rainfall? Or was that like what was that like what time of the year basically? And
Summer, generally the dates are on them. They were actually in the. Not.
maybe I didn't notice them, but I didn't see them on there. I apologize if they were on there and I didn't see.
Yeah,
them.
so they were from July 14, 2023. I was working with West River Farms. They were fixing salt fences and putting new salt fences, and there was just constant, erosion issues. There was, it's a giant dirt hill coming.
Right.
So it was something I checked frequently, and I don't know why those pictures aren't dated on the paperwork. Generally, it's something I do, but yeah, that was from one of the rainstorms from one of the times I checked last summer.
Have they been very reasonable to work with? Have they complied with everything you've asked for?
Yes.
Yeah,
with
they have.
Erosion control, and when we asked, Mr. Ressler himself, as well as his team, will go over there.
Okay, thank you.
One more question.
Oops,
sorry.
Go right ahead.
The maintenance agreement. What would that look like? Is it too early to say? What would your expectations be if there was agreement from the developers?
Well, I think a maintenance agreement would address all the issues that we've discussed here that were discussed in the minutes leading up to the approval of the special use permit to begin with. Plowing, paving, repairs. I think at a very minimum, those are probably the three things that need to be addressed.
Forever?
Yes.
Thank you. That's okay.
Thank you. Yeah. All right, so we will now move to the public comment portion. So in addition to the opportunity to comment live, members of the public were provided the opportunity to provide written comments. So I will ask, are there any written comments?
Other than
No?
the exhibits that came in the applicant, and nothing separate.
Okay. All right, so we will now hear from members of the public. We did circulate a list for those who wanted to speak, so I'm just going to go down the list. If you do not hear your name called and you would like to at the end, please stand up and just announce yourself. Yes. So all speakers must state their name and address. All comments must be germane to the appeal. And finally, out of respect for everyone who wishes to participate, speakers should keep their comments brief, concise, and limited to 3 minutes. So the first person on the list is Pedro, and I'm going to butcher this last name, Cristovar?
Yeah. Am I supposed to go here?
Yes.
All right. Good evening. I wanted to represent my parents because they're on vacation. They called me last minute and told me to show up. They live at 12 Shank Road. I lived there with them for many, many years. I do remember the erosion issues. Before the construction started, there is no erosion issues as of now. In terms of the maintenance on that road, it was always the junkyard that did it. He did it because he had to keep his business running. He was the one that went and sealed all the potholes. He's the one that had the negotiated paving of the road. I think he did it because it was beneficial to his business or to keep his business afloat. In terms of the maintenance and looking at this in a long term, eventually when this gentleman passes away, then who owns this? Let's say he doesn't have any kids. Who owns everything? Who owns the responsibility? Is it going to be all the brand new homes? They're going to pay for Shank Road to be repaved if the junkyard doesn't pay for it. My parents are 75 years old. My father at times, if it snowed a lot on the weekends, the junkyard was not open, he would have to take a snow blower and clear out the road. Maintenance, I mean, sure, you could say that Mount Everest needs maintenance. I mean, that doesn't really define anything. Maintenance could be like, hey, there's a whole bunch of boulders, you're gonna have to take some ropes, climb it up. There needs to be a long-term strategy, and if people are paying taxes on these properties, then they should have at least a road that could be usable. And it's not up to a private investor that owns a piece of land to say that, oh yeah, it's on him, because eventually that's not gonna be owned by anybody. So is it up to the property owners of the brand new homes, they're gonna pay for that new road? And then if the people on the property are paying taxes, then why don't they have a decent road? Why are some allowed new roads because those are older houses, they have a band-aided road full of potholes that leads it up to a business to put in their benefit to pave the road for a whole bunch of people that own that road.
Next question, Keith? Yes. Pedro,
Yeah,
how long have your parents lived there?
so I was trying to think about that. 2004, somewhere around
They
there,
paid-
probably before that,
They pay property taxes to East
Yep.
Windsor,
in South Windsor, both towns.
both South Windsor and East Windsor?
Correct.
So you think that it should be the responsibility of the town of East Windsor to maintain the road?
My parents paid their house in East Windsor.
Yeah,
I don't know where the other properties are.
yeah. But that house on Shank Road is East Windsor and the town doesn't maintain the road, correct?
Correct. Nobody maintains the road. Yeah.
Nobody maintains. All right, that's all. Thanks.
Next up is Stephen Caliendo.
Thank you. Not.
I swear it's the penmanship, not mine.
Teacher. Do you want my current address?
Yes.
Okay, it's 77 Mack Street in Windsor, Connecticut. It's a rental. Good evening. My name is Steve Caliendo. And my wife, Karen, and I are the contracted buyers at 48 West River Road. We were born and lived in Connecticut for over 55 years, worked in public service in the state of Connecticut, retiring, blessed to retire after 27 plus years in managerial service positions at Environmental Protection, Consumer Protection, Department of Administrative Services. The past 13 years, we lived in Florida. In June of this year, we came home. We wanted, and indeed we needed to be closer to our family at a time in our lives where our loved ones and we are experiencing personal age-related health issues. We expected to close on our West River Farms home in July. Now, 3 months later, we've had to relocate 2 times to temporary housing and currently remain in a perpetual state of limbo as we incur ongoing, unanticipated, unnecessary rental, storage, and other monetary expenses, which has created financial, personal, and emotional stress and hardship, quite frankly. In fact, just last week, we received a notice of a 33% increase in our storage rental fees effective November 1st. A lot of what has been said tonight, if you would bear with me, I've been marking it up because some of my thunder has been stolen. Thank you for all the previous presenters. But we are disappointed to learn of the town's history and actions regarding the Shank Road and Scout Hall property. Especially given the fact that the town of East Windsor and all the transfers and the various other things that have occurred
do not pertain to us, and we don't believe they pertain to us at this moment in time, other than the fact that we are now being denied the opportunity to receive a CO and get into the home that we have had built and spent a lot of money. We certainly respect any concerns of the Shank Road residents, but we're disillusioned to see that the town that we plan to live in essentially is expending taxpayers' money in a manner that we're not sure it's the most appropriate use of taxpayers' money. Back in 1989, I was elected to and served 4 years on the Town of Windsor Locks Zoning Board of Appeals. I know how challenging it can be to decide an appeal that might cause uneasiness or awkward feelings with some individuals in a small town. You know these people, all of you know these people as individuals who are your friends, neighbors, associates, or political and administrative colleagues. I'm fully confident, however, that each of you take your public service duties and official responsibilities seriously and without regard to any personal or political relationship or potential criticism. This board has a clear mandated responsibility to review and correct zoning officials or others' erroneous decisions or determinations that are not in conformity with the zoning regulations or with their general purpose and intent. And in this matter, not allowing current or future innocent purchasers like my wife and I the ability to move into their constructed homes cannot and should not be a proper or equitable application of zoning rules or regulations. On behalf of my wife and the many people that we look forward to having as neighbors and friends, people who want to reside in and become contributing members of this community, who have already invested their hard-earned money to live here, and who will be supporting the town of East Windsor financially through property taxes, participation in the elective process, and in many other ways. I ask, indeed I implore you, to provide the remedy that is the proper remedy in this matter. Please put an end to the bureaucratic delays and waste of taxpayers' time and money. Please stop the blame game against the West River Farms developer, who we believe has been acting in good faith to expeditiously resolve this matter. And please allow us to get into our new homes and experience the peaceful use and enjoyment that we looked forward to and expected when we had the home built. Now is the time to stop the difficulty and unusual hardship affecting all of us contracted purchasers. Tonight, especially tonight, please do what I think all of you know is the right thing that should be done, as time is the essence for all concerned. Thank you for your time. Thank you for your consideration, and thank you for your public service. Are there any questions?
Thank you.
Okay.
Okay, thank you.
Thank you.
Right.
I'll share it.
Yeah, I was about to
Yeah,
say,
yeah,
I
yeah.
thought that was you.
I had checked.
All right.
She's got to try to get to bed.
Gotcha. Next is Jason Davis.
I am from 175 Oakland Road, South Windsor, Connecticut, future homeowner of 44 West River Road. In this situation, I actually grew up in Norwich, Connecticut, and my dad built a house at the end of a road. It's a road, has a name, town owns it, but the town always said you want your house there, you have to maintain that access to that road. So the only way that I can see this be resolved so that we can all move into our houses, because it's not right that we're being held out from moving into our homes with our completed houses, is that it either comes out of the taxpayers' money or the people on the road maintain it. They go out and hire a plow driver and split it evenly between the four of them. I mean, I plowed for 18 years, maintained that road for 18 years. That's the best I can say. So thank you for your time.
Questions? No? Questions? Nope. Okay, next is Ryan Peterson.
My name is Ryan Peterson. I reside at 51 Round Hill Road in Berlin, Connecticut. I'm here tonight as one of the brokers for West River Farms and represented many of the homeowners who aren't here tonight. We want to bring a human element here. There's 11 houses under construction right now. There's another 4 that were to be built. So we have, 15 people who are waiting and have been delayed, really. One of our first homeowners actually was supposed to move in June. And, it's been 5 months since when she was supposed to move in. And there's no end in sight. So it would be nice to be able to come together and figure this out so that people can move into East Windsor and be welcomed as part of the community. All of the buyers are not current East Windsor residents, moving from elsewhere coming to East Windsor. And they want, not only is it stressful, it's supposed to be a happy time. And we just want to have them come and welcome to East Windsor. Thank you. Any questions?
Thank you. Thank you. Next up is Mike Howell.
Mike Howell from 38 Trombley Road. I've been a resident here all my life. Also a realtor for this development. Working with the builder. He's been very good. He's been doing stuff. I know the history of that area very well. And I think it's not right when I have clients and they're ready to move in. I said, sorry, can't move in because the town stopped the CO and you can't move in. And right now it's been in limbo. And it needs to be corrected. That's all I have.
Okay, thank you. Next up is Douglas Munson.
Doug Monson. I own 345 Scantic Road, also 1, 3, and 5 Skank Road. I find it interesting how everybody says, oh, we own it, we don't own it, we own it, we don't own it. We don't want it, that nobody wants to own up to what they have. However, within the last month or so, was I not at a meeting with you and the first selectman? What did they offer us? $65,000. You guys, you, the neighborhood, take over the road. $65,000 ain't much money. It ain't gonna go nowhere. That was pittance. It was almost an insult. All they had to do was maintain the road, plow the road, do their job. But everybody wants to go the sleight of hand. Okay, well, the contract said this and we've sold it over here at West Farms. Oh, well, we took it over here to this group. Oh, no, well, we don't know. We'll give it to South Windsor. So how are the people on Skank Road supposed to look at this? We're the ones that all we're saying is maintain the road. That's all we're asking. But everybody's sitting here fighting about it. You've had to stop building. And yes, right now the road is clear. But wait till we get the monsoon season come in. That water comes flying off the hill and it's going to be all over the road again, all the debris. They're giving you pictures of right now when it's dry. It hasn't rained here in about a month. And everything looks nice, hunky-dory. But as soon as the rain season comes in and that thick water comes down, you know, the drainage pipes have got filters over them. Water just builds up. They never bother to maintain them. The guy next door to me, they told us, oh, you can have a shed or a pool. Guy's got a gazebo. He's got a pool. He went on Skank Road to put his pool in, caused a ruckus, knocked down the trees. He was told to put trees back. You know how big they are? This big, and they ain't growing. The berm has not been taken care of. The only time they do anything is when you guys put pressure on it, or they think you're looking. Other than that, they ignore it. They walk away. It's, you know, people come through eventually and cut part of it back, but nobody really cares about Skank Road. We are a thorn in everybody's side. And that road has been there. I own 1900 was when the one house I have was built. That was just a cow path at one point. It turned from a cow path to this, and they had tobacco barns back in the back, so it was a road. Then the junkyard came in. That road has been sitting there off and on for well over 100 years, and it's been totally ignored. Now, I've only been around 10 or 12 years, and I live at the end, so for me to get out my 4x4 is not a big deal. But for the other folks, if there's an emergency, how are they going to get an ambulance down there if nobody plows? There is a person down there that has to be taken to the hospital on occasion. The ambulance comes in to pull this poor woman out to get her out for the treatment she needs. Now, if we get a big snowstorm and she's in trouble, she's a goner. Because everybody's arguing over whose responsibility this road is. You got elderly people living on this road and nobody really cares. And then people worried about their houses being built. But yet, we don't matter. We don't matter. And that's what hurts. It really hurts to sit here and listen to everybody. Look at my responsibility. All this is a sleight of hand with paperwork. Look at the size of these binders, 2-inch binders full of paperwork. 2-inch. I want you guys falling asleep listening to this stuff. Where does it end? Somebody take responsibility and do something, please. I can't say much more than that.
If the road was maintained by a company, West River Farm, here's the thing that
they're going to be gone.
Well, here's my point is I believe, and I've always believed that it should be maintained by the town because of liability.
Right.
Because you can't have a corporation maintaining a road and trying to get a fire truck or an ambulance down during a snowstorm. They got other projects. They got other.
They could care of.
So right now, the townspeople plow, or the residents plow the road?
Who, I'm not sure who was plowing it for the last couple of years. We haven't had that much snow.
Right.
Before that, Louis had somebody that would come in and plow.
And he's the owner of the South Windsor Auto Parts?
His son's now running the business.
Yep.
It's not Louis. But when Louis was there, Louis had the deals worked out with his buddies. They would use the excess asphalt to fix the road. And Louis was out there in the last year. He's in his 80s, guys. He's in his 80s, throwing around 80-pound bags of asphalt to try to get rid of that. An 80-something-year-old man. I mean, that's a little embarrassing.
Right. Thank you.
Well, I'm sorry, but all right.
Thank you. So that's the last name on this list. Is there anybody else in the public that would like to speak? Oh. Either one, but you need to come up to the front. Yep. Again, just state your name and address.
Melissa Tamara. I'm currently at 2A Spring Court in Broadbrook here in town. I'm prospective owner for 37 West River Road. Has not been started yet because of all of this. I was hoping to be moved in or shortly there, and now my home hasn't even been started. I can appreciate the Shank Road, you know, folks' position, but that I don't know why people who are others are being held up from moving into their homes and my home being built. And to minimize that, I don't appreciate that because we all have different things going on in our lives. I have a newborn at home that I'm away from to attend this right now. I've raised my daughter here. I've been here 14 years in this town. I don't think these actions by the town are good for East Windsor. You're holding up progress for East Windsor. Honestly, I don't, and I hope everyone remembers this when it's time to vote for the first selectman and this town, I will certainly remember that. I don't appreciate his actions for this town. And I'm not happy. I'm in a condo. I'm being held up from selling my condo. And we're all in limbo. I don't know when I'm gonna be able to sell my condo. I have a growing family. We're stuck in a small condo right now for who knows how long. How would you all feel not being able to progress and having a growing family, and not being able to move into your home and being stuck in a contract? I want my new home. I'm waiting for it. Don't know when it's going to be started. How would you feel? How would you feel? So I really want you all please to consider that and consider, like Brian said, the human element of this. Because there is a cost, and I don't know why it's being put on us to be responsible and be held up with our lives because of this. It doesn't make any sense, and it doesn't pass to me. Any questions?
Thank you.
Jagaloff, 125 Depot Street. And, you know, I'm pretty upset about this whole issue. I've been following it for months. And the thing is that there's no dispute that the town of South Windsor owns the right of way. And there's no dispute that the town of South Windsor owns the obligation to maintain access to that road. And there's nothing in the conditions that says that the developer has to submit a maintenance agreement or anything like that. And what really kind of galls me is that when you folks ask the question, what does the maintenance agreement look like? What's going to happen? And then you're told it's leverage. It's going to be used as leverage with the town of South Windsor to try to leverage them to step up and take responsibility. The town should have issued the notice of violation on the town of South Windsor. And the developer, and you know, I'm a selectman. I represent taxpayers. I represent residents. I represent business owners. And when a developer is doing their work and they're stepping up and doing what's asked of them, and now their COs are being withheld, I don't know why or how we got in this situation where you're sitting here having to make a decision about the fact that COs, certificates of occupancy for, you know, buildings that cost hundreds of thousands of dollars are being denied over this dispute. It really kind of galls me that you're in the middle of leveraging something to leverage South Windsor. I mean, there's other ways that this could have been done. They didn't have to not issue COs. And by the way, the COs were denied before the notice of violation went out. That's why West River Farms filed a lawsuit. So this is all about certificates of occupancy that are not being issued. They could have solved it some other way. They could have said, we're going to fine you $75 a day, or we're going to fine you $100 a day, or if they really thought that that was the issue. And so you're put in the middle of a dispute, a political legal dispute that has nothing to do with violations. As you heard, they've corrected all the deficiencies. The developer's not responsible. And to put you folks in the middle of actually having to make a decision over this really kind of bothers me. And it upsets me that this is even happening. So, you know, I'm asking you to reverse the decision and let those people that are trying to figure this out follow the proper legal and ethical pathways to solve this, and not have you in the middle making a decision to deny people the rights to occupy their homes where they've invested hundreds of thousands of dollars. This gentleman's put millions of dollars into that project for the benefit of our town. That's not the right way that this should be done. So you have an opportunity to fix this. I suggest you fix it, and the solution will come by some other means, the appropriate means, not through you folks.
Thank you. believe there's somebody back there.
Years. And my question is, kind of confused as to, I know that way back, I think it was like in the sixties, Shank sold the open area as well as South Windsor Auto Parts. They sold that land to South Windsor Auto Parts. And in the deed, it said South Windsor Auto Parts would maintain the road. And as well as the predecessor, I'm sorry, the Shank sold it to their predecessor. Pantaleos or something like that. And in that deed, it said they would maintain the road. Sorry, I don't like talking in front of people. You take a breath. And so and then South Windsor got it, and it was in their deed as well. So my question is, when did this leave the deed? Where, it seems as though somewhere along the line, that wording got changed or taken out. South Windsor always maintained a road for us, still tried to do it a little bit. And I understand it's quite the dilemma now, but I'm glad that someone is thinking of the residents of Shank Road, because it's something we've never had to do. Some of the stuff that was said wasn't quite accurate, but that's something to keep in mind. Where did this wording go? Why isn't it there now? Why wouldn't it have to pass from deed to deed to deed to say who's responsible? But it seems to have gotten changed. That's it.
Thank you. Is there anybody else? Yep, come on up.
Margie Rozier, 101 Reservoir Avenue in Broadbrook. Two things. You had mentioned complaints. Is that in their packet, the complaints and over time?
When I didn't have an answer for people because the town wasn't responsible for the road. I didn't have an answer for people, so it was just phone calls. I would tell them what I know, that we didn't have a maintenance, and I didn't know who would be responsible, and that's when all the research started. So there's a monthly ZEO report that gets reported to the Planning and Zoning Commission, the second meeting of every month. So some of them were logged on those, but other were just, I'm sorry. So.
And then I want to correct something. You had made it, the town attorney had made it seem like the deeds were the same between West River and Scott Hall Building Committee and Scott Hall Building to South Windsor. That is absolutely not correct. And if you want to look, I can wait and you can look online. Because there's two definitely different things in both of them. So one being the transfer to a nonprofit, another is the reference to a Schedule B for a special use permit. So that's wrong. Thank you.
Thank you. Anybody else? Seeing none? Oh, yeah. Is there online? Anyone online looking to speak?
Can't tell if it's a hand up.
I don't know if we.
Yeah, mute them, possibly.
Someone's big left.
Hello. Hi.
Hi.
Could you state your name?
Hello?
Hello?
There she.
Can you hear
Are
us?
you able to hear me? I'm not sure.
Yes, we can hear you.
You can hear me. Okay. Thank you so much. My name is June Notchin and my husband Joe. We've been trying to move to your town for about a year. Our house has been done for a few months and we are actually homeless now. So right now we are in South Carolina because that is the only family member that would take us. Our stuff is stored in where we were coming from, which is in Cape Cod. And we were trying to choose to retire near our daughter who just had a baby. And we thought we chose a really good town, but we just don't understand why it seems like you just don't want us and why you would choose to block certificate of occupancies for people. especially when you don't know the circumstances. My husband is a disabled veteran. We are senior citizens, and we're going broke over this. So we implore you to please take us and everyone else out of being a hostage in this horrible situation. Thank you.
Thank you. Questions? No?
No.
All right, is there someone else online that would like to speak? That gentleman frozen? Yeah, I can't tell if
Can't
he's.
hear it anymore now.
Yeah, yeah. Your thoughts? Yeah. I don't know if everybody knows how to put the little hand wave. Yeah, I
believe the
can't tell
person
you.
Left to right, the left corner is. Yeah.
Yes. Well, that's another two over.
I don't. Oh, yeah, he is moving. There.
Oh,
It's back up in the left. All right. You have to ask him to unmute?
I did.
Okay. Yeah. If you are looking to speak, can you unmute yourself or raise your hand?
I think we're all set.
Yeah, okay. There anybody else? One last call here? Okay. All right, we're moving on.
Ask if anybody else.
Yeah, anybody else?
Hi, this is Mohammed. Can you hear me?
For 89 years.
Mohammed, can you wait 1 second? We'll get to you.
Okay.
Member of the fire department for over 60 years. Was chief for 12 years. We've gone to fires down on Banks Road. We used to go down there, take cars apart down there and stuff for practice. The people live on that road, who do they pay taxes to? Town of East Windsor or South Windsor?
East Windsor.
People who live on Skanks Road, who do they pay taxes to?
The houses are East Windsor,
They're East Windsor, so they're
South
paying
Windsor.
taxes to the town of East Windsor.
South Windsor Used Auto Parts is actually in South Windsor, but the houses are all East Windsor.
If you're paying taxes to the town of East Windsor, the town of East Windsor should maintain Skanks Road, right down to the businesses down here. That gives us access for the fire department, for the ambulance. We need access to these roads in winter time. The town should, I'd say, grab it by the balls, but they should take that road over and maintain it all year long, plow the road. So we can get access down there. Thank you.
Thank you. All right, Mohammed, if you want to unmute yourself, you have the floor.
Yes, good evening, everyone. And I was living Windsorville Road almost 17 years in Bradbrook. I sold my house last year, and I get the house, in the West River Farm. And according to the paper, when I signed it, it says 6 to 8 months the house will be they was ready to move. But suddenly, I don't know what happened is. So now there was, getting worse and worse. And now is like, more than 50% my stuff in a storage. And then I'm living in Windsor in a two bedroom apartment. I have 3 kids and the 5 family members. And the last week they happened, it's on a driving in a parking lot, somebody stolen for all 4 tires of my son's car. And then my son's car on the block. So the reason is now I'm paying last 4 months for extra for my rent, storage. And now I'm paying $75 because I leased the for 1 year because the realtor committed to us, maybe the house will be, hand over within a year. Now it's more than a year. So now I'm paying $75 extra every month because I don't want to, sign the lease for another year. So now we are suffering. So if anything happened in my property when I was living in Broadbrook, if any damage in my property, I'm the responsible to take care of it. But now if the Shank Road is the coming of in the South Windsor, so the South Windsor is the responsible for the take care. So please, I'm requesting for the South Windsor or like a West Farm River, please resolve that issue as soon as you guys can. So then I can move it. I'm suffering. I'm paying extra $75 for the rent and a $25, almost $100 every month. I'm paying extra. That's not my fault. So I'm like, it's hard to explain what exactly, inflation and everything. I'm not to go by, that way, but at least I'm requesting to everyone to please resolve that issue as soon as you can. Thank you very much.
Thank you, Mohammed. Pretty good.
There's one in the back.
There's one in the back here, if you'd like to step up.
East Windsor, 8 Shanks Road. I'm there all my life. Honestly, I pay taxes in East Windsor. Do you really think South Windsor's gonna come and plow us out? Seriously? Without getting tax money from us? No, they're not. Our road is adjoined to Scannick Road, like all the other roads surrounding us. One lousy road, you can't come down and plow it. Is it gonna kill anybody to plow that road? There's plenty turnaround to go down and come back up. That's all. One sweep. That's all you need. Thank you.
Thank you. Thank you. Anybody else would like to speak? Okay. Does the property owner have any final comments specifically in response to the public comments?
I do, and also with regard to the town attorney's comments,
Sure.
the video's comments. And I will try to keep it brief because I know you've all been here a long time.
Can I just interrupt for a second? Nolan, do we have to vote to go past 10 o'clock or is other committees I'm on, we have to vote to go past?
Other committees have a time limit?
You don't?
Do not believe we do.
All right.
Might want to put that on-
So continue.
Time.
It's not an invitation to keep this going.
You got 2 minutes.
So forgive me if I suggested that somehow, with the open space, the town was skirting its responsibility by not accepting it. That's history. That's what happened. The first selectman minutes reflect that the town East Windsor did not want the property. I wasn't trying to apply anything there. But the fact that there is an active permit in the approval, issued through the approval, it doesn't mean that we have to go back and rewrite conditions, or that we can go back and rewrite it. We didn't try to undo any condition. My client had building permits for these homes and constructing them. Now, there was a question earlier trying to clarify Shank Road. It is a private road. It is a right of way. I think that term confused somebody, because when we say that, it just means usually that it's utilized by multiple parties, which in fact has occurred here. But it was my client, when he acquired the property, his entity bought the fee interest in Shank Road as well as the open space. That fee interest in Shank Road was then conveyed to Scout Hall, subject to the conditions in the deed, and that was subsequently conveyed fee interest in South Windsor, subject to the residents' right to access it. Now, There's been a lot of discussion about who has responsibility in that road now as we stand here today. Arguably, if we follow the town attorney's argument, the warranty deed to South Windsor indicates that there are which is Exhibit S, there are various title matters that are already on the land records that they are taking it subject to. It says that on the first page, these premises are hereby conveyed further subject to any and all provisions of any ordinary municipal regulation or public or private law and other matters set forth on Schedule B attached hereto and made part hereof, but only to the extent the same are still affected by their terms. And that Schedule B, which we went over earlier, specifically references the approval. So if we follow the town's argument that though that approval runs in perpetuity, runs with the land, I have no argument. They want to go chase after South Windsor and try to enforce this against South Windsor. Go ahead. I mean, I don't know how a court's going to decide that, but they certainly are in a better position to do that than my client. To the extent there's some confusion about the maintenance agreement and what it would look like, I'm confused too. I don't know how we create a maintenance agreement that we're not a party to. I mean, that just doesn't, I've never heard of such a thing. I can't imagine how that would happen or what, that's a futile exercise. You know, I certainly have no, no ability to create a document that South Windsor is going to abide by at this point. We can't fight the town's battle. No one on this board, fortunately, has to try to resolve this issue of Shank Road and who's gonna maintain it. I think someone made a comment earlier that they always thought the town should do it. The town of East Windsor, because that's where your residents pay taxes to. We don't have an issue with that, but we can't make that happen. In fact, when my client conveyed Shank Road, even though it's a narrow area, the part that he could, he actually gave a 50-foot right of way in case the town ever did want to create it, 50-foot wide area, not right of way. The interest in case the town ever did want to create it as a town road, and that's reflected on the map there. It's clear, Mr. Munson stated that it was always South Windsor Auto that was maintaining this. It was never Scout Hall. Scout Hall never did anything. I don't think we've heard any testimony from any of those Shank Road residents who live there that Scout Hall ever did a thing. Complaints, I don't think there were any written complaints submitted to the record. I assume that this was the owners of Shank Road, but you hear them. They want the town of East Windsor to take title to take this property and to maintain this road. It is a quandary for the zoning enforcement officer because she doesn't know what she's supposed to do with this private road. I understand. I can tell you the town of South Windsor is not going to maintain this property. Maybe with a lawsuit they will. Their town attorney, which is Rich Correll of Upside Kelly, has stated that emphatically. There was a phone call, in fact, between, as I mentioned, town leadership. And tonight, it's on their agenda at their town council to have a motion put before the town council to try to convey Shank Road back to East Windsor because they want to give the town manager authority to try to negotiate that. And I'm going to submit this as Exhibit KK. And just to clarify, my client certainly can't impose the condition of maintaining Shank Road on those property owners he already conveyed houses to. He can't recreate the wheel and now all of a sudden have an association that's going to be responsible. Yeah, my client is a one-person LLC, special holding company, meaning it only is involved in this one project, right? Any other projects or anything else you have are going to be a different name. So I think you all understand the difficulty of trying to have some private entity maintaining a road. I know Mr. Munson mentioned that there could be some more water issues. There's been no evidence of any kind of erosion and sedimentation issues since July of 23. That's what those photographs indicate. I actually realized that they were misstated because I looked up because I knew there was quite a bit of rain in July of 24. And I looked up to say, okay, the date of those photos, was there a lot of rain? No, there wasn't, which is how I contacted Ruth Ann to try to clarify. But you know when there was? July 1st, 1 inch of rain. July 6th, 1.11 inches of rain. This is this year. You saw the town engineer's photos. It's dry as a bone. So I'm going to submit this as exhibit LL. There's a very legitimate issue raised about fire and safety for the individuals living on Shank Road. I'm not going to minimize that. It's real. It's a real issue, especially now you've got some elderly residents down there. This isn't up to this board though, right? What's up to this board is to tell us if we are in violation of our subdivision approval. It's to allow these people to move into their homes. We can't resolve the issue of Shank Road. We're not in a position to do that. Town leadership is, and I do think that they should address it. There was a question about why a prior deed restriction wouldn't have run with the land. It does run with the land. And we did look tirelessly at whatever was in the land records. And I do think I have that deed from 1960. No, it's from it says 1964 in one place, December 31, 1964. And it was from various members of the Shank family, John, Virginia, and Van Shank. And they gave to Emil Pantelio and Finesta Pantelio. I think that's the deed that was being referenced earlier. The only requirement is the grantors, John Shank and William Shank, agree to be responsible for the ordinary maintenance of snow removal from that portion of said right-of-way that adjoins the property owned by each of them. That's all I could find in the land records. Like I said, these old rights-of-way, it's one sentence. It's not very clear. It certainly doesn't address how everyone on the street is supposed to maintain the street. So I'm going to submit that as Exhibit M. So in addition to the major impacts this is having on my client and his ability to sell his lots, I also want to remind the board members what a serious ripple effect this is having on all of his purchasers. You've heard from some of them tonight, but not even all of them. They all have lives to get on with, and they all want to be residents of this community. And we ask that you sustain our appeal.
Yes, you can.
I just one question. I'm not sure if this was mentioned. How many COs are there right now that are being held up?
I can tell you that. Let's see. So my client has completed and totally ready for COs 4 homes. He has another 3 that have just minor things to do that could be ready in a week or so, railing here or there. So that's 7 houses. He's got 4 others partially constructed. And then he has the others that are under contract that he just hasn't started. They're still in the permit phase because of the situation.
Has anybody backed out because they can't get the CO?
I don't think at this point, not at this point. They certainly would be well within their rights. And if people are going to, if this continues in court.
It's when we start voting it. Yep. Okay. Great. Are we good with questions? Yeah. Thank you. So now, does the zoning enforcement officer have any final comments specifically in response to the public comments?
Attorney, yeah.
No, thank you.
Then I will go back one more time to the property owner. Do you have any final comments?
No, thank you.
Okay, thank you. All right, so with that, we will close the public hearing. Right? Somebody needs to make a motion.
So moved.
Second, motion and second. All those in favor?
Aye.
Right, motion passes. Let's see. All right, we'll now move to our regular meeting, where we will discuss this hearing. Does anybody have any comments?
I know in previous lives, when I've seen developers come in and develop an area, they've maybe been affected or their neighbors are affected by what they're doing. So they've maybe like not maintained, but maybe paved a road like what we're talking about, but really never maintained it. It's more
After it's
like,
been damaged.
yeah,
or
it's like,
something.
here's a, like, you know, like a neighborly gesture, if you would, where they just made the road better, not in a maintaining avenue. And I've been around several of those, but some of the circumstances have been different, but it's still kind of bottom line. It's almost like that piece is almost separate from what we should be talking about, kind of.
Yeah, I see two different items here. The soil erosion. With any development, you're gonna have soil erosion, and it seems like it's been taken care of ongoing, so it brought some attention to the road, so the road comes up. I think it's two different issues. My opinion is that the road should be under the jurisdiction, responsibility of the town. Because it's a road with houses on it, they're paying taxes to the town, property taxes. It shouldn't even really be an issue, and I think it's almost like extortion for the town to be holding it up over the developer and holding the COs back from them moving into the town by having this road issue involved.
Any comments? Any comments?
I do think that the developer was responsible for the road, at least initially. You know, it was a condition of approval. And I'm not so sure it was taken seriously at the time. There was a lot of conditions of approval that, you know, that was one of them. There was a lot of time. Developer could have gone back to P and Z. Or at least could have been more precise with the language in the transfer agreements so that there would not be this ambiguity that apparently there is. So I don't think that the developer is blameless. But it's 9 years later. And I am bothered by the fact that there are people who are being held up who can't get into their houses. And I do question as to who should have the responsibility of that road. East Windsor, South Windsor. So I do not want to see this strung out in court and leave these people stranded. So it's my feeling at this point.
Okay. Scott, do you have any comments?
I do not.
Yeah, I tend to agree with you. That at some point it did seem like that was part of the agreement or part of the deed. But I do not understand the maintenance agreement that is being asked of the developer. I don't understand how they could possibly ask another entity to take over maintenance. I don't know why it would be their issue. So that certainly has me at pause. So if nobody has any more comments, questions, concerns, I will entertain a motion. And I believe we have to do it in the way of, do we approve
Yes.
the appeal? Right?
Yes, approve the appeal, and it has to be a, super majority 5-4, or at least 2 pass.
Yes.
5 voting members.
5 voting members, yes. So, and Dave, you cannot vote because
That's what I was gonna ask you.
of the applicant.
All right? Yep. I'd make a motion to approve the appeal. ZBA 2024-04, applicant owner West River Farm LLC. Got it broken up here, so I don't know what else to say.
I would just continue reading.
Okay, notice appealing the notice, approve the appealing of notice of violation of special use permit. June 9th, 2015, approval due to lack of proper installation and maintenance of sedimentation and erosion control measures in regard to, it was called the Skank Road. 329, 331, 339, 341, Scannick Road, East Windsor, MBL 003, 34-60, 62 and 62-A, zone MFDD. Did I read the wrong one?
No, that's a.
I think that's correct, right?
Got second?
Yeah.
There's a motion and a second. All those in favor?
Aye.
Aye. All right, all those opposed? Nobody? All right, that is unanimous. Congratulations. Moving forward, if I can find,
Take a motion to postpone the other items on the agenda to next month.
That's all? Oh, we gotta,
Yeah.
we can't just leave.
where in the world did my,
Approve the minutes.
It's fine. It's June.
I had that
Yeah.
here.
Yeah, I did hear your, Scott, we're gonna give a second for the room to clear a little bit. It is a little loud. For everyone out there, we are still doing a meeting, so if you could take your conversations outside. I think that's part of that. All right, so we are still going. Scott made a motion. I'm gonna have Scott say it again.
Make a motion to table all the other agenda items until next month.
Second.
Yeah, that's what say you still can't vote. I don't-
I second.
Still can't vote.
Okay, there's a motion and a second. All those in favor?
Aye.
Okay. That motion passes, and then I believe.
Motion to adjourn.
Yep, motion to adjourn. Is there a second?
I second that.
There is a second. All those in favor? Aye. That motion also passes. We are adjourned at 10:07 PM.
Good morning. Thank you.
Thank you. Thanks for coming.